using your phones. I know you're not making a phone call, but if you're on your phone and it's outside and you see it illuminated, that means you're using it. Please step outside to do that. Thank you. Please rise. The justices of the Appellate Division of the Supreme Court First Department. Hear, all persons having business with the Appellate Division. Draw near, give your attention, and shall be heard. Please be seated.
Good afternoon, and welcome to the Appellate Division First Department. I will give you our usual spiel. We have read your cases. Your briefs are familiar with the issues raised therein. We have 7 hours of requested argument time. Clearly, we cannot grant 7 hours worth. So please ask for what you need, not what you want, or I will be forced to do it for you. Okay. People versus Robert Goodwin.
For appellant 8 and 2, Your Honor. Affirmative plus 8.
6 and 2 and 7. Viscaino versus City of New York.
Appellate 5 and 3.
Okay, 6 and 2 and 6. Matter of Kenneth S. versus Janice C. is submitted. Gordon Ostridgic versus Life Medical Technologies.
Appellant request 5 and 1, please, Your Honor.
Respondent requests 5, Your Honor.
Okay, 5 and 1 and 5. Powell versus Building 874 Flatbush.
Appellant request 4 and 2, Your Honor.
Defendant respondent, exotic master, 2 minutes.
3 and 1 and 2. People v. Jean Herrera.
Yes, appellant request 6 and 2, Your Honor. If you will request 6 minutes, Your Honor.
6 and 2 and 6. In-house group versus Total World.
Appellant 3 and 1. Respondent 3 and 1.
Is there a cross appeal?
No.
3 and 1 and 3. Wu versus Sabrina Balski Interior.
Appellant 3, please.
3 minutes. Respondent is requested no time. People versus Randell Smickel. 5 and 2 and 5. People versus Raymond Reed.
Your Honor, appellant requests 5 and 1.
4 and 1 and 4. TG Children. Okay, 3 and 1 and 3. Vargas versus Virus Construction.
Appellant, 5 minutes, 1 for rebuttal. Respondent 2, so, 3 minutes. Appellant, cross appellant, then respondent.
5 and 2, 5 and 1 and 3. Jonathan Perez is submitted. Kutcher versus Sohagia. Sorry if I mangled that respondent's name. Thank you so much. Submitted. Baychester Retail versus City of New York. 5 and 1 and 5. People versus Harry Weinstein, and this case will be called last on the calendar so that we can get rid of all of our inventory, okay? And your... Okay. Okay. Request granted. 10 and 2 and 10. Jerome Walker. People v. Jerome Walker. Submitted. FX Funding versus Fox RX. 3 and 1 and 3. City of New York versus Horlick. I understand we received a phone call from someone for the Horlick case. For which part? Are you here for both Horlick and 1600?
I represent the city for both.
The city? Okay. I'm saying the appellants called and said they were having trouble getting here. So I know that they want to argue. How much time are you can respond to both appellants together? Okay, how much time do you think you need? Okay, so I'm going to give 4 and 2 to each of the appellants and 4 and 4 for the city to respond to them, okay? All right. And Eisner versus City of New York is submitted. First case on the calendar, People versus Robert Goodwin.
Good afternoon, Your Honor. Megan Tallmer for defendant appellant Robert Goodwin. Appellant's chief contention on this appeal is that he was denied his constitutional right to represent himself at trial. For purposes of this argument, I will assume Your Honor's familiarity with the record of appellant's appearances in court from February 1 to April 25, 2018. In 1974, in People v. McIntyre, and 1975 in Herrera v. California, the Court of Appeals and the Supreme Court, respectively, recognize that both the federal and state constitution guarantee a defendant the right to represent himself at trial. Although McIntyre has been the law for almost 50 years, as recently as last year in People v. Trammell, this court found it necessary to remind both calendar part judges and trial judges that under McIntyre, when a defendant makes a timely, unequivocal application to represent himself at trial, the court's only function at that point is to conduct an inquiry into whether defendant's waiver of his right to counsel is both knowing and voluntary. Trammell cautioned the lower courts that it's not enough to give lip service to a defendant's constitutional rights while essentially negating them by failing to have a prompt waiver inquiry, discouraging a defendant from exercising his constitutional rights, refusing to relieve assigned counsel over defendant's protests, or by provoking a defendant into misbehaving over the court's failure to comply with its own legal obligations.
Counsel,
case,
can
Your
you,
Honor,
can you tell me why, because I'm assuming that you believe that Judge Scherzer's questioning was insufficient. Explain to the court why the judge's inquiry regarding his age, his education, his work history, and his criminal history falls short of the standard you are describing.
Well, it's not necessarily that it fell short, Your Honor. It's that it was suspended when, it was completely fine up to the point when defendant told Justice Scherzer that he was under the influence of pain medication for surgery that affected his thinking. And she appropriately at that point said, then you can't make such an important decision today. We'll have to put this off. So her inquiry was fine. It just wasn't ever completed, and there never was a final determination by Justice Scherzer or by any other judge on the appellant's application to represent himself. That was the problem.
So the medication that the defendant spoke of was for a surgery, not a mental...
I believe he said he was still taking pain medication for recent surgery. And at that point, she quite appropriately said, well, look, we'll have to stop for today. Contrary to the people's representation, she didn't deny the appellant's application. She twice said, I am denying it for today, meaning I can't make a decision today. You're not even in your right mind at this point. So her inquiry was completely proper. It's just that it was never completed. When appellant reminded her on the next date that they were in the middle of the waiver inquiry, she cuts him off very abruptly, sends the case out for hearing and trial, but assures him that he can take up all the issues as to how he wants to proceed with the trial judge. But then when he tries to raise it again with Justice Edwards the next day, she says, apparently relying upon an incorrect notation on those index cards informally kept by preceding judges, well, look, your application was already denied. She says, that ship has sailed. So the people's claim that appellant somehow abandoned his request to proceed pro se, well, once a trial judge tells you your ship has sailed, any further protest on his part would have been futile and could have resulted in his expulsion from the courtroom, as Justice Bybin had threatened. So, Your Honor, in this case, there's no dispute that the appellant made repetitive, insistent invocations of his constitutional rights. There's no dispute that on 2 separate occasions, the Calendar Park judge did not engage in the waiver inquiry. There's no dispute that when it finally was commenced on April 17th, it was never completed and that there was never a final determination. Given these indisputable facts, a straightforward application of McIntyre and Trammell require reversal. I'm going to save for rebuttal my answer to the people's attempts to justify the failure to have a waiver inquiry because my time is almost up. Thank you.
Thank you.
May it please the court. Good afternoon. I'm Karen Schlossberg for the people. On those facts, it does seem perplexing. If those were the facts of the case, it would be surprising, but those are not the facts of the case. The facts of the case are that the defendant appeared first before Justice Bybin and had been difficult and argumentative and disruptive for many months before.
Well, Trammell says that is not an excuse to not engage in the proper inquiry that is required when this request is made.
Well, I wouldn't want to argue with you particularly about what Trammell says, but my understanding is that that the issue in that case in particular was you can't induce disruptive conduct by denying the motion to proceed pro se, which is what I think this court felt happened in that case.
Well, in Trammell, he, like this defendant, repeatedly asked to go pro se.
Right.
And the courts did not engage in the inquiry and instead kept on posing every possible obstacle other than what the law requires, which is a inquiry into the fitness of the defendant to proceed pro se. So explain to me how that was satisfied here.
Well, okay, that's not actually what happened in this case. I mean, first of all, I think we have to be clear. The law is if a defendant is disruptive, that is a grounds to deny the
Right, counsel,
request.
I'm going to ask you again because I asked you a direct question and I expect you to answer it.
I'm trying, I'm sorry, Your Honor.
So the question is, explain to me how there was a satisfactory inquiry here that one can say that his constitutional rights were not violated. Because let me just say, speaking only for myself, I saw nothing in this record of his behavior and his insistence that he had a constitutional right to represent himself. He repeatedly said that.
He did.
And told the court that the court had no right to force a lawyer on him that he didn't want. So he could not have been more clear. And as was said in Trammell, it is understandable that a defendant who continues to assert his constitutional rights and those rights are being ignored would be frustrated with the court. So
I agree that that's understandable. What I disagree with is that that's what happened here. And I would just urge the members of the bench to look back at the record before Justice
So
Biden.
where in the record, because this does seem a case very much like Trammell, where the disruptive behavior was in response to the court not addressing his inquiry, and you're saying it's otherwise, where in the record can you show him being disruptive except in response to being denied his right to counsel? And where in the record can you point to the court ever during an inquiry in response to his repeated requests again and again and again, not just a few times to represent himself? When did he ever get a response to that?
That's what I'm trying to get to.
Well, that's what I'm asking.
Before Justice Biden, she was not denying his request. She was very clearly not denying it. She kept saying, I'm not ruling on this right now. I'm sending you to another judge. And he was so disruptive and obstreperous and argumentative.
Why wasn't she ruling on it? Isn't that her obligation
Because she wasn't.
to make a ruling on it?
No, because she was just sending the case to another judge. She said, I'm going to let that judge decide whether you should try it.
And that's what every judge did. Every judge said, I'm not ruling on it, I'm not ruling on it,
No,
I'm not
actually-
ruling on it. He never got his inquiry.
Actually, what did happen is this. She said, I don't think I should be the one to rule on this because I'm not going to be handling your case. But he refused to let it go, and he kept arguing, and he had been disruptive, by the way, just for the record is clear, he had been disruptive long before he ever brought this issue up.
But
and she had
wasn't
noted
his
it.
disruptive?
So
I mean, can't we? It certainly seemed to me from reading the transcript that his behavior, which you describe as disruptive, reflected his frustration at not getting a straight answer. On 2 occasions, Justice Biden said she wouldn't rule on the application. She'd send it to somebody else. He was frustrated by that, and then he began talking back. It's hardly surprising. He wanted a ruling, and he wasn't getting it.
Well, then she gave
But I
him a
still
ruling.
don't see anywhere where anybody gave him the opportunity to have the kind of colloquy that our decisions require.
Well, Justice Biden denied it on the ground that he was being so disruptive, which I
No,
think
she
the
didn't
record
deny it.
supports.
She deferred it.
No, she ultimately denied it. She said, you know what, then I'm denying it because you are being argumentative. She almost removed him from the courtroom.
Actually, she said, if it's up to me, I'm denying your request. I don't think that's a denial. I think that's a deferral.
Okay. Well, I read that as a denial, but I understand that position. But on the next date before Justice Scherzer, he walks in and immediately says, I want to assert my right to represent myself. She says, okay, and she began the inquiry. And as my adversary pointed out, as they were going through it, when she said to him, have you ever questioned a witness or talked in public by yourself? And she did try to go through. She was very calm and very entertaining of this motion with him. She told him how important it was. But when she got to that point, have you ever done that? Have you ever spoken in public? He said no. And what he said was, actually, what I wanted was a lawyer. I wanted a different lawyer. So he said at that point, and she said, well, that was going to be my next question. Is your request to go pro se because you're dissatisfied with your attorney? And he said yes. Then she continued talking to him, and he started talking about how he wasn't thinking clearly because of the medication, and so they agreed together this was not a good day to make this decision. But after that, and I think this is what's crucial, it was after that that he continued with his disruptive, he was obsessed with this issue of hearsay at the suppression hearing.
I have to stop you, but if she already had decided, okay, we're not dealing with that issue, then his disruptive behavior doesn't really enter into the equation. As I understand McIntyre, there's a whole procedure here. And the procedure is, he unequivocally states, we have no dispute, he stated it before multiple judges, right? And before a ruling can be made, the judge has to do a searching inquiry to make sure that he has the capacity to waive his right to counsel. That's different than fitness, right?
Yes, but that's not the case.
No buts. This is just me asking questions right now. And then the third step is if the court finds that there is capacity to waive counsel, the court should make a decision that the person can either go pro se or they can deny it based upon the fact that it would be disruptive to the court process. And what is of concern to me is that that procedure wasn't really followed. And so maybe, just maybe, if there had been a full searching inquiry, and then the court made a decision and said, based upon what I've observed, he will disrupt court proceedings, that might be okay, but it seems like a lot of steps were missed.
May I answer that?
Yes.
Even though my red light is on. I just want to say there seems to be an assumption here that if a defendant is being obstreperous and argumentative and interrupting and being disrespectful and would not allow for the fair presentation of the issues, that they still have to go through the McIntyre inquiry, and that has never been the law. That is not the law.
It's never not been the law.
It is not the law. I mean,
No, I disagree with you, honestly.
I would refer
I don't think that just because a defendant's being difficult, that relieves the court of a very difficult burden of having to go through the searching inquiry.
Look, counsel, all I can say is the case law says, exactly as my colleague has laid it out, if after the inquiry the court determines that based on his or her observations, this person is unfit or would disturb the process of justice in the courtroom, then the court can make that decision. But the court cannot say, you're being disruptive, so I'm not even going to engage in the process.
I would just refer.
Nowhere have we ever held that.
I would just refer the court to People v. Williams, which is cited in my brief. There are several cases cited in my brief where the judges, there were implicit findings that the defendant would be too disruptive, and so their right to represent themselves was deemed forfeited without any McIntyre inquiry. In fact, the defendants had been removed in some of these cases from the courtroom without even going through any questioning at all about this issue. So I disagree. I respectfully disagree that the McIntyre inquiry is required when a defendant is being obstreperous and argumentative and interrupting. I think that's only when there's a question about voluntariness or whether or not it's a genuine request. But I thank you, Your Honor, for your time.
Thank you.
Your Honor's questions have addressed the issues far better than any rebuttal. So unless you have any questions of me, I will rest.
Okay, thank you.
Thank you very much.
All right, Viscaino versus City of New York.
Good morning, Your Honors. My name is Neil Kafko from Kafko Schnitzer. I represent the plaintiff appellant. The appellant is a TLC driver who had gotten a haircut on Broadway and 141st Street. He had a few beers, and he was walking to a friend's house towards 144th Street when he realized, obviously, he couldn't make it, and he urinated on a plant. At that point, he met two women who he knew, who asked him for a phone number.
So I think we're familiar with the facts and the disputed facts in this case. And so as to the violation concerning public urination, there is no dispute that there was probable cause for that.
Absolutely, Your Honor. That's absolutely correct.
All right. And so the issue really comes down to the DWIs and the DUI. With respect to, there are conflicting accounts of what happened with the police encounter with the plaintiff when he was in a car and they said that he was attempting to drive off, and he said
he
no.
drove off. He got into car, drove off.
I accept that. They said they saw him drive off, right? And he said, no, I was sitting with my legs out. I was trying to get keys, and he had a witness who corroborated what he said.
Correct, Your Honor.
So the question, I guess, is two questions in this case. One is whether the probable cause on the public urination can serve as probable cause for the DUI.
The DUI prosecution.
Right. Correct, for which you are suing for malicious prosecution. And whether, given this disputed issue of fact, can the city, who has moved for summary judgment, can they establish as a matter of law no actual malice, right?
Absolutely correct.
Okay.
Now, under the federal courts of Janetka versus Dabe and Johnson versus Knorr, Poser versus Dougherty, the federal, there were 3 decisions which actually addressed the question whereby where an analysis can be done by the court to see whether the second charge can be maliciously prosecuted. And in this instance, this case fits that perfect analysis. The violation is not a lesser included or offense of driving a vehicle or being intoxicated, nor does driving a vehicle intoxicated have anything to do with littering or urination. The 2 events were separated by time and space. And there's a decision in a Queens court called Pugash versus Borgia, where the court said that Janetka didn't apply in that particular situation because it was that case was about private parties. And they said it had to also do with a relationship, that both events came from the same relationship. But they went out of their way to discount the Janetka ruling, which by implication, the converse or the inverse is true, that if it's a case not involving private parties, that Janetka would hold in the state of New York, where an analysis, I mean, it would be extremely unfair to have someone prosecuted for DWI for a public urination charge, or for any much more serious crime for a minor crime. And the police, the opportunity for police misconduct or prosecutorial misconduct is so high if a police officer can just frame somebody or fudge something and prosecute someone for something else. The idea that the probable cause for a minor infraction can preclude redress on a more serious charge of malicious prosecution is just unconscionable. And in this situation, there are 2 distinct ideas of what happened here. There are 2 distinct stories. The plaintiff appellant says, I did not drive the car. I did nothing mechanically or electronically to put this car in operation. Under the statute, the car must have been operated. And the criminal patent jury instructions say clearly that the car has to be mechanically or electronically done something to the car to put it into operation. Now, there's a case of People versus Prescott that was quoted by the respondent, and that the court specifically says in that case, there is no criminal liability for attempted drunk driving.
Counsel,
the legislature did not create a statute.
I'd like to ask you a slightly different question. How would you distinguish, why isn't this case controlled by Roberts versus the City of New York? How would we distinguish this from that case?
Well, in Roberts versus City, the plaintiff in that, or the defendant in that case was indicted. So there was a presumption of probable cause, and there were also 2 ID witnesses which created probable cause. All the cases that the city is really quoting, there's either been a probable cause in actuality, so that or that the case or that the charges were actually lesser included offenses of the same charge, or they were involved in the same incident. In this case, it's 2 distinct events: urinating a block away, coming back to his car, and being arrested for driving a vehicle while intoxicated. Any other questions? I'm sorry.
You'll have time on rebuttal.
May it please the court, Antonella Carlin for the city. The Supreme Court correctly granted a summary judgment on the malicious prosecution claim for several reasons. First, there was probable cause for all the charges, including the drunk driving charge.
Isn't there an issue of fact on this drunk driving case? We've got a witness who says, yeah, I asked him for something. He never got into the car to drive. He never drove the car. Those are diametrically opposed to what the police officer said. I don't understand how that's not a question of fact. And if the jury believes the plaintiff here, that would be sufficient to constitute malice. A police officer who lies on police reports, lies in order to arrest someone for an act they didn't see them commit. I can't even fathom something more clear. Malice.
So I think here, if what plaintiff says is true, I mean, based on his version of events, there was probable cause. Because what he says is that he...
Probable cause for the urination.
For drunk driving.
No,
so
not based on what he said.
Operating a car...
Counsel, stop. He said he didn't operate the car. So if you want to tell me based on what the police officer said, there's probable cause, I can accept that argument. But to say that the plaintiff here who says, I did not drive the car. I never put the ignition in the car.
Driving a car and operating a car are very different things. The Court of Appeals has said that operating a vehicle is broad when you're talking about the drunk driving statute. It includes any act, any intentional act that alone or in combination with other acts.
Doesn't it require the ignition in the car?
No.
No?
No.
But the plaintiff doesn't say he even put the key anywhere near the ignition.
No, so
all
what
he
he
said
does
was that the key was in the console and that his feet were hanging out the door.
So what he
I don't
said
understand,
in his
excuse me.
Also, let my colleague finish her question.
I do not understand how you can say that given the plaintiff's account that the keys were never in the ignition and his whole body wasn't even inside the car, how you can tell us that that constituted operating a car.
So, okay, he said that he got around, with these keys in his hand, he went around, he sat down in the driver's seat, and then he leaned over the steering wheel. So if you're a police late at night and you see someone urinate on the side of the road and then who appears to be intoxicated...
How do you get from, excuse me, how do you get from he leaned over the steering wheel to that was driving a car, to operating a car?
If you see someone sitting in the driver's seat and they go like this, I mean, the law cannot be that before a police officer can arrest someone for operating a vehicle while under the influence, they have to actually see them drive away.
But that's what this police officer said. So I don't understand.
He didn't actually say that.
Wait, let me finish. So I don't understand how you can otherwise get probable cause based on facts that were different than those that were perceived by the police officer.
So the police officer didn't actually say that. He said at one point in the memo book, which was not ever given to the district attorney, he said, got into the car driving off, stopped, or something to that effect. But in the actual report that was given to the district attorney, he said, attempted to drive away, which is what you see. I mean, maybe it's not the most artful language, but he saw someone who had just urinated in public, who appeared to be drunk, get into a car, sit in the driver's seat with his key out and lean over. He thinks he's attempting to drive away, so he stops him, which is what we would want a police officer to do in this situation. Now, that's not to say that at most, what he's saying would be a defense to the actual criminal charge, but that doesn't mean that the police officer didn't have probable cause here. It's late at night, you see someone urinate, you see them walk sit in the driver's seat.
The question is there an issue of fact as to probable cause? And you said earlier that based on plaintiff's own account, it was clear that there was probable cause of DWI, and I still don't get that. What you're saying is that from his account, the police officer could have thought that he was operating the car. Well, I don't really see that. I certainly don't see that he was, in fact, operating the car.
But it's probable cause. He doesn't have to, it's like a drug transaction, right? You can have probable cause to arrest someone if you see behavior consistent with the drug transaction. You don't actually have to see the drugs change hands and money, right? It's kind of similar to that. You see someone with their key.
The problem is here, is when you're looking at probable cause, it's what did the officer perceive at the time. I agree with you on that. He didn't perceive what the plaintiff is now saying are the score of events. So you can't rely on the plaintiff to say the plaintiff's account establishes probable cause.
No.
Right? So in fact, we come down to, you move for summary judgment, you have to establish probable cause as a matter of law. And we are asking you, I think consistently, maybe in our different ways, isn't there an issue of fact on the factor of probable cause that would preclude you from getting summary judgment dismissing this complaint?
And I would submit that there's not. So in the complaint report, he said that he saw the plaintiff urinate and then get into the driver's seat and attempt to drive away.
We know all of that. And when we have a hearing,
so that's his
somebody's going to decide who's telling the truth and who's not. You're telling me, and this would be consistent with a summary judgment analysis based upon what plaintiff said there's probable cause. The only problem with that, and this is really what I'm asking you, is that probable cause, as you rightly have argued here, is based upon the officer's perception of what's going on. And his perception was not what the plaintiff said happened.
Sorry.
So isn't there an issue of fact
about
what the officer perceived at the time of the arrest, so that we have an issue of fact about probable.
So what I was just referring to when I said he said in the complaint report, that's what the officer said. So the officer said, very similar to what the plaintiff is saying, without all the details, but I saw him, I'm defendant urinating in a public place, then I saw defendant get into automobile and attempted to pull away. I stopped. Upon stop, defendant, a strong odor of alcohol on breath, slurred speech, bloodshot, watery eyes. So what the plaintiff said just confirms what the police officer saw at the time. He urinated.
All right. We've got the argument.
Yeah.
You've got it. Thank you. Ostridgic versus Life Medical Technologies. You may proceed.
Good afternoon, Your Honors. Chris Savro, Pollock, Isaac, and DeSico on behalf of the plaintiff appellant, Gordon Ostridgic. I suppose a good place to start would be first that a lot of these times these inquiries depend upon when an agreement isn't executed by the defendant who's seeking for it not to be enforced. I think the first point is that the record supports an inference, especially on a motion to dismiss, that the defendant, Ms. Fitzgerald, who's the sole, if we look to page 65 of the record, the counsel indicates that she is the sole board member for the defendant. And then if we turn over to page 78, we indicate at the top, she says that she mailed her signatures for the agreement and the conflict waiver to the plaintiff's office. So from that point, I think that it's clearly established that the defendant intended to be bound by the agreement. We can also note that when the federal court was notified of the settlement agreement, it was on consent by all parties. It noted that over the course of 4 months, there was heavy dispute as to the terms, but all of those terms and that dispute had been resolved. All the material terms were agreed to, and part of the final written settlement agreement that was signed by Ms. Fitzgerald, and therefore it should be deemed binding upon the defendant based on that alone.
Here's the question, though. What effect, if any, is the fact that several of the plaintiffs did not sign on to the agreement?
Well, I think
that's undisputed, right?
Correct, Your Honor. That's undisputed that even after several months, and it's also undisputed that the defendant had a great amount of due diligence on her part, following up, asking for these signatures, and that this is a nightmare that most plaintiffs' firms or any firm would have to go through, where you have an associate who is winding down his practice and leaving and doesn't finalize a case as he's supposed to, and then it turns into a disaster.
Yeah, I understand, but that doesn't deal with the legal problem. What's the legal significance?
Sure. Yes, Your Honor.
Did the settlement require that? Did the settlement require the signatures of all 55 of the plaintiffs?
Ultimately, it would, Your Honor, but it doesn't require that to be binding. And that's a huge difference that this court has repeatedly relied upon. We cite to Kowalczyk v. Strupp, which was the case that first set this forward. Then there's the case of Lord versus Maryland Modeling Management, which Justices Gish and Kern were on the case. And this morning, I submitted via NICEF another case, and I brought hard copies if the court would like it. Justice Manzanet, you were on this case. It was a matter of Philadelphia Insurance Indemnity versus Kendall. That was decided over this summer. And that also held to the Kowalczyk standard, which is also the Second Circuit standards, that full execution is only binding if it's expressly required as a material term. So to answer Your Honor's question, this speaks to performance more than anything else. And as this court held over the summer in the Kendall case, the execution, this is a quote, execution of a general release was essentially a ministerial condition precedent to payment, end quote. It doesn't affect whether or not the agreement is binding in of itself.
Okay, you want to reserve your time?
Yes, Your Honor. Would Your Honors like the hard copies?
Sure, you can give it to.
Keep one this morning.
You may proceed.
May it please the court, Niall Cook on behalf of defendant respondents. Defendant respondents request that this court uphold the well-reasoned and fleshed out decision of the Honorable Judge Bluth in the Supreme Court. The fact of the matter is there was no settlement agreement agreed to. The material terms were never completely fleshed out. There was...
Didn't she repeatedly state that there was a binding agreement and that the only problem was the other side wouldn't execute it, but that she expressly told the court that there was a full and binding agreement?
Well, the plaintiff in this action has...
She sought the help of the court to enforce it.
I'm sorry, I missed that last
She sought the help of the court to enforce the agreement.
She sought the help of the court to determine the status of the case in general. The letter that she sent to the court...
It was because she was taking the position that there was an enforceable agreement, and the only thing preventing the consummation of that agreement was the behavior of the plaintiff.
Not necessarily, Your Honor. Throughout the course of this action, the plaintiff has flip-flopped between... If you look at the pleadings in the Supreme Court case, the initial argument was that the defendants had breached the agreement because she failed to sign it. And now they proffer arguments regarding that there was some oral agreement without providing any evidence of what this oral agreement was. And then since settlement agreements must be reduced to writing and signed, they now offer some argument that partial performance by them and not by the defendants who they seek to bind.
Are they in fact arguing that it's the unsigned written settlement agreement that is the agreement that they are now trying to enforce? There was a complete written agreement. The only issue is that it wasn't signed. So it's not an oral agreement. It's not any of the things part performance. It's an actual written agreement.
Well, that's kind of my point, Your Honor, is that they flip-flop between the arguments that they've been offering.
Well, that's really their argument now, so that's the one I think you need to address.
Okay, so their defendants proffer that the agreement that was provided was not binding. The material terms were not completely worked out. The side agreements were never, ever proffered. To this day, they were never provided. And if the defendants seek to enforce an agreement, they can't have it both ways, essentially.
What's missing from the agreement? What essential terms are missing from that written agreement?
The agreement was supposed to also include exhibits or side agreements that were a retainer agreement and a draft complaint, a proposed complaint to sue the defendant's insurance carriers. And that's extremely paramount to this proposed settlement agreement, because if you look at
But was there a provision in the agreement that it would not be binding until those were proffered?
throughout,
I think what was striking about this is, for example, there was no express agreement that the parties would not be liable until it had been executed. Similarly, I don't think there was any express agreement that they wouldn't be liable until those attachments were made.
Well, there is, throughout the, if you look at the history in the record, throughout the negotiations, the defendants continuously stated that they need the plaintiff's signatures, all of the plaintiffs in the Supreme Court, or in the federal case. And that, if you look to the opinion, is what which Judge Bluth
Well, they may
relied
have
upon
said
as well.
that, but the agreement itself didn't say
The
that.
agreement
Excuse
itself
me,
does not say
The agreement
that.
itself did not say that,
But
correct?
the agreement itself was just a draft. That's potentially why it was not signed. It was never, the material terms were not amounted to. There are other parts of the agreement that are attached to the record that are flatly contradictory to themselves. So there was never reviewed by an attorney. It was never agreed to. The material terms were simply not worked out here. If you look at page,
So I'm just trying to understand how, if what you have just said is true, then why is the dialogue with the federal court an opposite message? We've settled.
well, that dialogue initiated from the plaintiffs themselves. Long before settlement,
But you're saying you weren't at the table?
I don't know
The judge
why.
just took the plaintiff's side for it?
I don't know why they submitted to the court that settlement was complete when settlement was not complete. I can't say that. I don't know why that they did not request the federal court to retain jurisdiction over a settlement agreement. I don't know why they did not go back to the federal court within the 30-day safe harbor time that the judge provided. I can't answer those questions.
I know you keep saying you don't know why. On the other hand, it was done, and you were on notice of it, or at least your client was. They didn't protest. They didn't write to the federal court, no, it's not settled.
Right.
No, this is a draft. No, we're not,
That's my point.
I just don't understand. You make a representation to the court, or a representation is made, we've settled. If that's not true, doesn't the other side have an obligation to say, no, not true, court, don't take it?
The federal judge specifically provided in his order that if settlement had not actually been agreed to, that the court
I know it did, but that's not answering my concern. You said it was not true when they represented to the court that this was a settlement agreement. It was a draft. It was incomplete. It wasn't agreed to. But silence from the other side?
Well, to that point, Your Honor, the defendant or the plaintiff can't do the same thing here. They're suggesting that there is a binding agreement, yet they have not performed any of it.
Counsel, that's not answering my colleague's question, with all due respect to you.
I'm sorry,
okay?
maybe I don't understand. I'm sorry.
We keep on asking, why didn't you complain? Why didn't the defense, if there was no settlement, you certainly had an opportunity to say so, instead of going down this make-believe path of, oh, we might have a settlement, we'll, in 30 days.
Your
I
Honor,
don't understand.
Your Honor, I believe that she did. It may have been after the time that the plaintiffs had to bring their case, but it's not her responsibility to argue.
So
the
you're
plaintiff's
saying
case.
it's perfectly okay for defense counsel to appear in court and stay silent when the other side is saying, we've reached an agreement. It's okay, you're saying, for defense counsel to say nothing, allow a case to get discontinued off of the the court's calendar, and in 30 days, if that's not my understanding, bring it back. You say nothing?
She tried everything she could to get this resolved, to get this settlement agreed
Did she
to.
say something on the day that the judge puts on the record this case is settled?
I personally was not there.
Well, I assume you've read the transcript, counsel. Are you saying that she was barred from speaking out to say that? That the federal court wouldn't let her say that?
I am not saying that.
So, but I assume you've read the transcript of that, and I don't know what you mean by saying she tried to say it.
No, I'm not suggesting that she tried to say that. I'm just suggesting that.
But I don't understand. Was she represented in that case below, if not by you, by somebody? Was she represented?
Excuse me?
By counsel.
By counsel.
Oh, was she represented? I believe so.
I tell you what's troubling about this, honestly, what you're saying. You know, we're all judges. We've all been trial judges. Attorneys come to us, and when they say they have a settlement and we mark it settled, we have to be able to rely on that. And if you take no action, I think that her attorney, whoever it was, had a duty to speak if somebody was perpetrating a fraud on the court by giving a settlement that didn't exist. I do.
I don't disagree with you, Your Honor.
Okay, good.
But
All
here,
right.
that simply didn't happen. And
All
there's,
right, we're out of time. We wanted an answer to the question that had been asked a couple of times, so thank you. You may proceed.
Good afternoon again, Your Honors. I'd like to just pick up on that last point and direct the court to 2 pages of the record. First page is page 99. That's the letter that informed the court in 2017 of the actual settlement itself on a consent of all parties. And I would note that all counsel of record were copied on that, which is Respondent's Counsel's office. I would then refer the court to page 79. And this is when, as Your Honors were discussing, Carol Fitzgerald went back to the court, albeit after the 30 days. And I should note, the 30 days was for all parties to address the court and say there's a problem. But on page 79, we'll note at that first paragraph at the top that she says that she spoke with Respondent's Counsel's office prior to sending this letter in, to your point that if there was no settlement agreement, then she shouldn't have said that, A, she signed it on page 78, or on page 77, that the purpose of us agreeing to the settlement agreement and later on, our concern with agreeing to it was to essentially get finality. And now I'll go back to this court's decision from earlier this year in Kendall again, and what they're discussing about her wanting the signatures, and she has every right to want them, and maybe there is more need for guidance to bring finality, a harsh deadline. Some members of the plaintiff's class shouldn't get their settlement if they are unable to execute it. I understand that. But that's more of an expression that they're worried that some of the plaintiffs might renege on their responsibilities. And in Kendall, this court held, quote, an expression of concern that a party might renege presupposes the existence of an agreement, unquote. So the question here on the motion to dismiss is, with all inferences for the plaintiff, was there intent to be bound? Not whether or not there is full performance. And yes, the record speaks fully.
And actually, the arguments that are made that it wasn't performed on your end of it, and most significantly that nobody commenced a claim against AIG, might bear upon whether anybody gets recovery under the agreement, but at this stage of the proceeding, it doesn't stop there being the formation of a valid agreement.
Exactly, Your Honor.
Thank you.
Thank you very much. Good to see you all.
Powell versus Building 874 Flatbush. You
May
may
it please the
proceed.
court, I'm Jeff Four. I'm representing here on behalf of Building 874. I submit that the court below erred in not granting Building 874's motion for summary judgment, dismissing plaintiff's action.
Is there a non-delegable duty on the part of the owner to
Yes,
maintain the sidewalk?
Yeah, I absolutely concede that under the administrative code, there is a non-delegable duty.
Based on your argument that it was trivial, did you submit an expert's report or anything to substantiate your claim?
We submitted the deposition testimony of the plaintiff. She couldn't describe that there was any elevation differences, and she testified succinctly that she did not catch her foot on anything. She just slipped. I submit that even though it's a non-delegable duty, it's still the plaintiff's obligation to show that there's either actual or constructive notice.
You're moving for summary judgment, so you have
Yes.
you have the burden of proof, not the plaintiff.
And the court below held that we met the burden, the
How
initial
did you meet the
burden.
burden, though?
Thereby,
How did you meet your prima facie burden of establishing that the defect in the sidewalk was not actionable?
the deposition testimony of the plaintiff, the
Her inability to describe the defect doesn't give you a slam dunk.
No, but
you have to put forth some evidence if you're going to claim that the defect is trivial.
Well, we also said our argument was two.
I mean, she did break her wrist, right?
Yes, she did.
So,
but
okay.
our argument was trivial defect was one of our arguments. The other argument was that we didn't have either actual or constructive notice, nor did we create the condition.
But counsel, before we go off the trivial defect, the plaintiff described it as a cracked up sidewalk. And you're asking us to infer from that it was trivial?
Under the case law, just because the sidewalk's cracked doesn't mean it's not a trivial defect.
But don't you
or
have
it
to
is a
show
trivial
us
defect.
something?
That's
Counsel, come on. The case law is pretty clear. When we find that there's trivial, there's evidence of its trivial nature. Where is that in this record?
The photographs and the plaintiff's own description of.
think these
Is there
photographs
even, you?
Honestly, there's one photograph where the sidewalk is so obviously and badly cracked that I just don't think it supports trivial defect.
Nor does it support a lack of at least constructive, if not actual, notice.
Well, there's no testimony that established for how long this condition existed.
Precisely. And who is that on, since you are the proponent of the motion? It's on you.
It's on us to establish that we didn't have actual or constructive notice. And I submit that that was established in the court below, and the court held that.
Okay,
And
thank you. You've run out of time. You'll have 1 minute on rebuttal. You may proceed.
Good afternoon, Your Honors. May it please the Court, my name is Richard Sclaren, and I represent Defendant Respondent Exotic Hat Master. We seek affirmance of that portion of the lower court's September 9, 2020 decision and order which granted our motion for summary judgment, dismissing plaintiff's complaint and all cross-claims, since, quote, the relevant evidence reveals that the alleged defect in the sidewalk was not located in front of the store leased to and occupied by Exotic Hat. That's our point right there,
That's the
Your
bottom
Honor.
line. It's
What's-
not in front of your store.
Well put, exactly correct, Your Honor.
Got it.
And if we find that you in fact prevail on that issue, then we don't need to go into any of the issues regarding who is responsible under the lease in terms of indemnification, insurance, et cetera, right?
Correct, we stopped there.
And we stop there, full stop.
Full stop.
Thank you.
Thank you, Your Honor.
Counsel, you have 1 minute.
Thank you, Your Honor. I respectfully submit that there was an issue of fact as to where the action specifically occurred. Plaintiff's testimony at the deposition was unrefuted that the accident occurred in front of the hat store. That's Exotic Hat.
But we have a photograph that shows the cracked sidewalk in front of the other store, not in front of the hat store.
Well,
Correct?
Your Honor, the
Is
angle.
that correct?
There is a photograph, Your Honor, but I want.
And the counsel, there's a photograph of a cracked sidewalk that is not in front of the Exotic Hat store.
I submit to the court that the angle of the photograph does not definitively demonstrate that it's not in front of the hat store.
Did you
And
give
what
me a
evidence-
photograph with a better angle?
No, I did. We did not, Your Honor.
And you're the proponent of the motion, right?
Yes, Your Honor.
Okay.
Thank you.
People versus Jean Herrera.
Good afternoon, and may it please the court. John Vang for Jean Herrera. I'd like to talk about the sufficiency point here. The evidence didn't establish depraved indifference. The Court of Appeals has made clear in Feingold that depraved indifference is a separate mental state from recklessness, which has to be proved. While Mr. Herrera was absolutely and indeed reckless here, he persistently maneuvered, weaved, and swerved.
Let's talk about, there's two different phases to this
Right.
car chase. One phase was on the West Side Highway, and then the next phase was on the Henry
Yes.
Hudson
Yeah.
Parkway. So even if we accept your argument about, what happened on the West Side Highway, once the defendant went onto the Henry Hudson Parkway, where there was really no way to get off, and he was staying in one lane, what swerving was going on at that point? Wasn't he just staying in the right lane and going?
Well, just to be clear, he's still trying to evade this unauthorized chase. And when he got onto the Henry Hudson Parkway, he was still driving around cars. Now, at some
But
point,
once he got on, was he still swerving? Was he just staying in the right lane and charging forward?
well, when he got on, the evidence shows, the video shows that he was still driving between the spaces between cars. At some point, and there's no video to show this, at some point he found himself holding steady in the right lane.
So for an extended period of time, he was holding steady in the right lane. He wasn't swerving anymore at that point.
Immediately before, but I don't
Right
think that,
when that crash happened, he no longer was trying to swerve anymore.
but that, I don't think that's an indication that he didn't care at all. I think under the circumstances,
Why not?
holding steady, because
I mean, it's depraved indifference.
yeah,
Why
it's not.
doesn't that show a depraved indifference? Not putting aside what happened initially, by the time he got on, that he kept going all these blocks, and then he kept going to a place where he could have gotten off, and then he stopped swerving and he just went. Why doesn't that show, with a high risk that he was going to kill someone or hurt someone, why wasn't that a depraved indifference?
And Your Honor just pointed out, with a high risk, depraved indifference requires more of a showing of just recklessness and even
Well, I mean, if
inevitable
you're
risk of death.
driving on, for you, the right-hand lane,
Right.
but for oncoming traffic,
Yeah.
it is the fastest lane on the highway.
Right, yeah.
So he is traveling northbound on the southbound left lane of the Henry Hudson Parkway. I can't think of anything more absolutely devastating to a driver. You're driving along, and all of a sudden you've got headlights coming up on you, and there's nothing you can do.
Well, to be clear, Your Honor, at that point, the collision had occurred at a point when he couldn't see, and you're right. He's absolutely reckless.
So he continues to barrel through.
Yeah.
He is on a blind part of the highway, and there's no attempt to stop. There's no attempt to curve and turn around and go with traffic. I mean, at no point. There are several places from 57th Street when the Henry Hudson starts, right, till 79th Street. There were several places where he could have, had he been on the left-hand side, had gotten onto the grassy parts of the highway. Instead, he's on the right-hand side. There's no shoulder.
Right. And I think the point is, first of all, we have to keep in mind the context that he's trying to evade capture.
You know, you mentioned that before, and
Right.
I don't understand how that helps you. That he's trying to evade capture, as if that is a defense?
Well, it's relevant to whether he doesn't care at all, right? Because this is
No, wait a minute. That's not Maldonado. No, you're trying to get under Maldonado, and Maldonado said swerving kind of indicates when you're in a car chase that you're concerned about hitting other people, right?
Yeah.
But there are, but Maldonado didn't throw out the prior case law, right?
Did not, no.
Still good case law, right?
Right. It's still good case
So
law.
one of the things, so we can look at the fact that certainly early on in the chase he was swerving.
Right.
And then there came a point, as my colleague indicated to you, he stopped swerving.
Right.
The other thing I think that I want to make sure that I understand, there's no claim here, and in fact, you really can't claim that he didn't understand that he was traveling the wrong way into traffic, correct?
He certainly understood that, but that's not
He had
dispositive.
to understand it, right? Because it was a major highway, right?
Yes.
And honestly, when he was on the West Side Highway, moving up to Henry Hudson, cars were coming at him. So he had to know he was going the wrong way, right?
He absolutely understood that.
Wait, let me finish.
Sure.
And he had a barrier next to him that was the middle barrier. So he had to understand that he was, that further reinforced his knowledge. He was going the wrong way, right? Don't
Yes.
you think?
Right.
Okay. All right. So, and also, let's be clear. When he was brought to the hospital and they did some toxicologies, no alcohol, no drugs, right?
Sobriety doesn't impact the analysis here.
So actually it does. He had his faculties about him during this chase, correct?
Yeah, but in Maldonado
And in fact,
Tyndall, they were also
let's
sober.
leave Maldonado out for a minute and let's go to Heidgen, which dealt with people who were otherwise impaired. And they said that the impairment of their perceptions didn't affect their mental state. So clearly, if being drunk doesn't negate the depravity, the utter depravity that's needed for this state of mind, then the fact that you fully have your faculties is a fact that cuts in the other way.
I actually don't think it does cut in the other way.
Why is that?
Because in Maldonado and Prindle, the defendant there was also sober as well. I mean, that's
But
kind of
he also
baseline what we
said,
expect.
he affirmatively said, I didn't know I was going the wrong way on a street, right? He said it.
I mean, I think that's a statement that he made that was also relevant to manslaughter.
And
which
it
is what he
wasn't,
should be
and it
convicted of.
wasn't a highway where you could have been obvious you're going the wrong way in Maldonado. It was a side street, wasn't it?
That's true, but the fact that he was going the wrong way doesn't eliminate the possibility that it negates depraved indifference. You have to establish that he didn't care at all, and given you can't just excise.
Well, I think what you're getting at, and this is something that I agree with you, that these cases are like snowflakes. Each one turns on its own facts, correct?
They absolutely do.
And the question is this more like a Maldonado case, or is this more like a Huygen case?
Right, and
Forgive me if I'm
And I think the critical thing to keep in mind here is there's no evidence showing that he knew what the highway would look like at that point, right? Number one. Number two,
that he knew what?
you can't excise.
What do you mean, what the highway would look like at that point?
Because there's no evidence that shows he's trying to flee this unauthorized police chase from the police, which itself doesn't mean that this
There's
is.
no allegation that this is somebody who's an out-of-towner, right?
No, there's no
Because every New Yorker knows,
right.
okay, that West Side Highway is busy. It doesn't matter what time.
Right, but the point about it is that what Maldonado instructs us is that these consistent acts earlier, they just don't dissolve. The mental state just didn't dissolve because of the circumstances of the highway change.
But are you saying, wait, are you suggesting that someone who may have started out, I mean, I believe one of the cases that, I can't remember the name of it now, one of the cases where depraved indifference was found, the gentleman kept on swerving, trying to avoid hitting someone, runs over a child. His passenger says, you gotta stop. He says, no, I already killed somebody, I can't stop. So I don't think it's accurate that just because initially you may have attempted to avoid, that lack of mens rea exists throughout the whole fact pattern. Not necessarily. But you'll have time on rebuttal, because we're way over.
May it please the court, Alexander Michaels on behalf of the people.
So Maldonado's a problem for you. Isn't it a problem case for you?
No, I don't think Maldonado.
Why not? Why shouldn't this be more like a Maldonado case?
Maldonado is not a problem for us at all because Maldonado, there is affirmative evidence that the defendant was trying to avoid hurting people. Yes, he was driving extremely dangerously. There's no doubt about that. But there is affirmative evidence.
What was that affirmative evidence other than the fact that he was swerving to avoid people?
That's it.
No, defendant specifically told the police when he was arrested, I didn't see the person that I initially hit because I was looking back over my shoulder to see whether the police were in my rearview mirror or were behind me. And then defendant also specifically said that when he crashed into a parked car at the end of that chase, he did so only because he was trying to avoid people that were actually in the street that he was going to crash into otherwise. So there we have really...
Didn't he run after he crashed the car?
Yes, he absolutely did, but that's not relevant.
I'm sorry, I really... Maldonado is not so easily swept out of the way here, counsel.
Well,
because here you have a defendant who did, early on in the chase, swerve and attempt to avoid hitting cars and people. So we have a very similar fact pattern, certainly early on in the chase, okay? So I would like to hear where in this chase scenario you think you have the strongest arguments to show that he ceased attempting to avoid and was now just trying to flee.
Well, there are two intervals, actually, that are particularly relevant to the issue of depraved indifference beyond what we see in Maldonado. The first interval, it's actually the second phase of the chase, as one of your honors referred to it, is when he's on the Henry Hudson Parkway. There, he is making no effort of any kind to avoid oncoming cars. That's for 20 blocks, roughly a mile. He's making no effort of any kind to avoid oncoming cars. The idea that that constitutes conscious avoidance, which is what Maldonado is discussing, is preposterous. There is nothing there that demonstrates any attempt to avoid.
And there is evidence that during that stretch of the events that cars are coming at him, right?
Yes, yes, there's
Yeah,
surveillance
so-
footage that shows that 8 cars pass him in the few blocks north of 57th Street. And then there's also testimony from the officers once it gets outside the surveillance footage that there are still cars occasionally coming by. The traffic was sparse heading downtown according to the victim who was driving. So we don't know exactly how intense that traffic was. I would also like to point out that even before the defendant reached the Henry Hudson Parkway, at 42nd Street, we saw the defendant was in fact depravedly indifferent in relation to the possibility of harming other people. As the Maldonado case explains,
Explain what was happening on 42nd Street,
Sorry.
because we've read the Maldonado case backwards and forwards.
Yes.
So instead, apply your facts
So
to
Yeah, sorry, I got turned around a little bit there, but at 42nd Street, he's trying to flee the police. He might also be trying to avoid harming others, but he sees a man on a Vespa scooter in front of him. And as to that man on the Vespa scooter, he does not try to avoid that person. He drives straight ahead, barrels forward to exactly where the Vespa scooter was. Luckily, the person on the scooter saw him coming and dove out of the way and was narrowly clipped by him. But the point is, defendant made a choice at that point. He could continue fleeing. He was able to continue fleeing even if he ran over the Vespa scooter, and he was utterly willing to do so. He obviously was not seeking to avoid harming other people when he was avoiding other vehicles, because in this case, when he didn't need to avoid another vehicle in order to continue fleeing, he willingly did so. So we see that even before he gets to 57th Street, and then at 57th Street, it becomes crystal clear that for the 22 blocks that the defendant continues driving, he's making no effort of any kind to avoid harming other people.
How long was the chase?
The chase, I think it lasted a total of 6.5 minutes, if I recall correctly. That information is most easily found in the logs of the police cars' movements.
This is the only vehicle with which he made contact?
No, there were multiple other vehicles with which he made contact. He sideswiped 2 cars at the intersection of 17th Street and 8th Avenue when he was pulling off of the sidewalk after he'd been driving along the sidewalk. He sideswiped those 2 cars. And then as he was approaching 42nd Street, he hit one car, tore part of the bumper off as he was swerving across the street, and then he hit that Vespa scooter that I was mentioning earlier and tapped it, only because the scooter got out of the way. And then at 43rd Street, he hit yet another car. So I think the total tally is at least 5 different vehicles before the fatal crash on the Henry Hudson Parkway.
Okay.
Unless the court has any questions, the people ask that you affirm.
Thank you.
I'll just speak to that last point with respect to the sideswiping. You know, the Court of Appeals has made clear that even woefully inadequate measures will negate a finding of depraved indifference. Now, he did sideswipe these cars, but that was as he was trying to maneuver and get around them. That was the situation with Spiegel and Lee. Now, the thing with the Vespa
He
scooter...
also drove up on the sidewalk where there were pedestrians,
I'm sorry,
didn't he?
there were no pedestrians, actually. There was no evidence that there were pedestrians on the sidewalk. And actually, with respect to Lee, which is what I think Your Honor is referring to, he actually was not even on the sidewalk. The complainant actually testified that he was just a little bit on the sidewalk as he was trying to get around him. So Maldonado was made clear...
A little bit is on the sidewalk.
But there are no, first of all, there are no pedestrians on the sidewalk, but that's also as he's trying to get around. The key thing to keep in mind here is that this is, we are not in the, people...
The sidewalk is not made for vehicles to drive on, right?
We are not in the people re-register era. There has to be a showing that the person does not care. Escalating recklessness is
But how can you show that he cared when he aimed for the man who on the Vespa?
He didn't, but that's actually not an accurate characterization of the record, Your Honor. The person who was on the Vespa believed that was happening, but he actually had swerved around him. So that's actually not an accurate characterization of what happened. What happened was there's a near miss, but in Maldonado, the court made clear that even near misses are not enough to make out depraved indifference. The key thing to keep in mind here is, one thing I was gonna say to you about he was holding steady on the barrier, but there was an inference to be drawn there that he was holding steady in the event that there was a break in the barrier, for him to get off. Again, there's no evidence.
Break in the barrier. Never mind.
I'm sorry.
Never mind.
But the key thing that's missing here is just that what we're pointing to here is just his awareness of an escalating risk of a.
How fast was he driving?
There were varying speeds, and it was based on
at the point of look, the impact had to be was catastrophic.
Right. And it was,
okay?
Yes. And it's absolutely a traumatic...
I've never heard of someone have their intestines come out of their body from the impact of a front-end collision.
And this is,
Because the belt pulls you in so tight.
this was absolutely a horrific accident. He is absolutely guilty. He is absolutely guilty of a reckless manslaughter. But the evidence does not negate the fact that he didn't care. He had repeatedly and consistently shown that he cared. The accident only occurred
I
at a
don't
point where he couldn't
understand that
see.
argument. I have to tell you. It shows that he cared. And I don't understand your argument that the whole thing is because he's trying to avoid police, trying to avoid apprehension. How is that a defense?
First of all, the avoiding the police apprehension is relevant because this is not a situation where he's going on a joyride, down the street. The police pleaded guilty to the fact that they shouldn't have chased him and that they created a dangerous environment. So that's relevant to why it is that he's trying to flee away from.
Who pleaded guilty to that?
I'm sorry.
Police officer.
Police officer pleaded
Two
guilty?
police officers, yes, they pleaded guilty to the unlawful chase and to creating a reckless, environment. But the lack of care is the essential part to the depraved indifference point, because the Court of Appeals has said, indifference has to be taken literally. If there's any indication of care, that negates this.
The only thing that you rest your care on
Right.
is that he was swerving and trying to get out of the way.
I was trying to get this point out before. He was not, at the point in which he was on the Henry Hudson Parkway, when he was holding steady, there were cars coming around him, on the left side. So you're right.
Of course they were going around him. He was in there, he was coming right at them.
Right, but
Of course they were going around him.
But you're right, Your Honor, but this was a rapidly evolving situation. This
No
was rapidly, and
kidding.
he found himself in that lane holding steady. And what our argument is that under those circumstances, holding steady with your bright headlights on while people are coming around you is, trying to minimize the
You
risk
think
of harm to
that
others.
you described? Well, may I ask one more question?
Sure.
You might-
Sure.
Tell me what impact, if any, or where does it fit into the rubric of these facts
Sure.
that he had a passenger who got thrown out of the van when they ultimately had the accident and who was screaming, "He wouldn't let me out, he wouldn't let me out."
I mean, I don't think that's relevant.
How's that not depraved?
I don't think that's relevant to the
How is
analysis.
that not relevant? That man or woman could have died too.
I mean,
We're lucky we don't have 4 dead bodies.
But what's relevant to the depraved is whether he didn't care, and we can't just excise all of his repeated
You
conduct from
have
before.
someone in your car screaming for you to stop because you're driving like a maniac, and you continue.
Right.
You clearly don't give a damn about the life sitting next to you. What care did he have for that passenger?
I guess, but I think the
None.
issue is not specific for the
None.
passenger, but it's the evidence of care that we see in the other cases. This is not one of the rare cases of depraved indifference. We
Okay.
ask for for reduction.
Thank you. In-house group versus total world domination. Sorry about that.
Oh, yeah.
You may proceed.
Good afternoon, Your Honor. If it please the court, my name is Mark Block. I'm arguing on behalf of defendant appellant. In-house and Kushner, as architect and contractors, have obligations to complete submission with the Department of Buildings as part of work on the subject premises, or pay for the cost of the new contractor and architect, the cost for a new contractor or architect to do so. That's estimated about $15,000 to $20,000. Courts have held that claims against architects and contractors only start to toll after completion of the project, which include closing of work permits and issuance of certificate of occupancy. My opposition
When
relies
do
on a
you think
release.
that when were the permits supposed to be closed out?
I'm not sure.
Well, then what is the effect of the 2014 amendment with its releases? Were they supposed to be closed out before, or were they supposed to be closed out after? Were they working together even after that?
That's an excellent question. The C of Os had not been closed out. The releases there is a question of fact which precludes motions to dismiss at this point, and that is, did the respondents, or did they withdraw from the Department of Buildings before or after the amended settlement agreement, which would then affect whether or not the release is ripe or not, and then even if they did
What's the issue
withdraw.
of fact? When do you say that they withdrew? When?
I'm sorry, I didn't hear that.
Well, I'm asking you, what's your best facts here? Because there was a release, in the 2014 amendment, correct? There was.
I couldn't hear you.
There was a release in the 2014 amendment. There's no issue about that, right?
Well, yes.
So unless you have events coming after that or actionable events after that, why isn't it precluded by that release?
Because in 2018, the respondents re-put themselves into the building by submitting a letter to the Department of Buildings asserting that they are the architect of record on the building. That is found in the record as, I believe, R53. So by putting themselves back in the building, by reasserting themselves as the architect, they then had the obligation to close out those.
So the obligation, your theory of this case is that their obligation stemmed from their actions in 2018. It established a relationship.
It reestablished the relationship for which they have been paid. They have been fully paid under the settlement agreement. And that work included, the work as an architect includes closing out the applications.
That's not in the amendment, though.
No.
That obligation.
No, but by reasserting themselves into.
Is it statutory?
No.
And do you contest your adversary's proposition that these permits typically expire in a year's time?
I don't contest that. My point is.
But that's relevant here, no? Because by the time, it was shortly after the work was, they were no longer on the job that the permits expired, no? Do I have that right?
They filed their complaint within the year of the, they filed their complaint and the payments were made, I believe, within the year that they had reasserted themselves as the architect of record. They had an obligation to close it out as payment was completed or was being completed.
Okay.
Thank you, Your Honor.
Good afternoon. May it please the court. My name is Adam Cohn. I represent the plaintiff respondent in this matter. Let me be clear that my client is not an architect, and he did nothing in 2018 with regards to reasserting himself or opening permits or anything like that. My client is a builder, a general contractor, and they have no obligation to close out or maintain or do anything else for these building permits. They, that obligation, which is alleged by my colleague, cannot be found in the contract and it cannot be found in the law. General contractors do not owe fiduciary duties as architects do. For this reason, Judge Marin of the lower...
Now, am I right that in-house group is the construction arm of Kushner Architects?
I wouldn't characterize it that way. It's a separate company.
But they're owned by the same people, right?
There's one individual who is a principal of both the architecture practice...
Kushner.
Yes, ma'am.
Right, okay. I mean, you talk about it like they're, two ships that are sailing in the night in opposite directions.
Well, I mean, it's not quite like that, but they are separate entities.
I understand the legal implications of it.
Yes, ma'am.
You can proceed.
Well, I rest, frankly. I believe the lower court, Judge Myron, correctly ruled that there was no obligation with regards to maintaining these permits, and that was the basis of his granting our motion to dismiss.
So what happened in 2018? Did your client insinuate itself into a relationship with the appellant such that some obligation existed?
As he says, they reinserted themselves.
I do not represent Kushner Studios. I represent In-House Group. In 2018, In-House Group did nothing except carry on its 10-year mission to get paid for the work that it did for Total World Domination back in 2009 or 2010.
Okay. All right.
Thank you.
Are these yours? Just one point. The dismissal was for all claims. As we asserted in our counterclaim, the interrelationship between Kushner and In-House is such that it's unclear where one begins and one ends. If there's no further questions, we rest.
Thank you.
I'd also point out there are an extra pair of glasses here.
Oh, don't, leave it there. The officers will take care of it later. Thank you.
Thank you, Your Honors.
Wu versus Sabrina Balski, Interior Designs.
May it please the court, Brendan Marks for plaintiff appellant. Your Honors, the lower court awarded $411,000 on top of $438,000 that had already been paid, making for $849,000 for nothing more than coming up with a design scheme for an apartment, overseeing the construction of a single bathroom, and ordering some furniture and other materials.
But that's not really the point, is it? I mean, the question is, what did the contract allow compensation for? So I understand your client paid a lot of money and doesn't feel that she got her due for it, but that's not what we look at in a breach of contract, is it really? The amounts, as I understand it, from what the lower court did, were derived from the contract. Why wasn't that right? What did the court get wrong about the contract or what was performed or not?
Multiple things. First, there was no breach of contract by our client. Our client had two obligations under the contract. Number one was to pay all invoices upon receipt, which she did. And number two was to deliver contractor invoices. The contract doesn't have any timeline, any deadline for delivery of contractor invoices, but the clear implication of the contract was that those invoices, the contractor invoices, would be delivered upon completion of construction, and then the parties would then settle up at that time. However, our client also prepaid $75,000 against the 30% fee. At the time of termination, only $150,000 to $200,000 in construction had been completed, generating a 30% fee in the range of $50,000 to $66,000. So our client, having prepaid $75,000, was actually ahead, and therefore no damages accrued under that portion of the contract. Similarly, no damages accrued under the second portion of the contract because...
But as a matter of proof, at the trial, wasn't your client required to produce the invoices? She didn't have them, right?
The contractor invoices were produced, and the record shows that no fees were earned because our client had paid in excess of the 30% fee that had been generated. In addition, she had
produced all the invoices that were directed to be produced?
I beg your pardon?
She produced everything that she was told to produce? Didn't you testify that she tried to get them from the contractor and contractor wasn't being cooperative? No? Did I miss something?
The record shows, and it's all laid in our brief, that everything that was required to be produced was ultimately produced, all of the contractor invoices, and that's our client's only obligation under the contract, other than to pay the bills, which she indisputably did.
Well, there was some work that she had not paid for fully, the customized mill work. And it was very clear when the designer submitted the bid for it, that she was requesting 50% of the cost of that upfront in order to begin the custom work, and that the other 50% would be due. And that item alone is almost $300,000. That's what was due.
I understand, Your Honor, but the facts show that our client did pay the 50% that was billed.
Right, but that leaves a remaining 50%. Once you order custom work, you have to take it. You can't cancel the order because the artisan has already started working on it. So you're bound, as was this designer.
We did a detailed analysis, which we lay out in our brief, showing that our client paid $119,000 in excess of the defendant's out-of-pocket expenses. So not only were there...
Your client understood. This woman was a designer, decorator. You understood she was going to get a markup on that?
Yes,
right?
we did. Absolutely.
So the contract was to pay her the amount that was set forth in the contract. It wasn't necessarily what she was billed for the mill work, was it? I mean, the case is baffling, I have to say, but the court tried it and decided the credibility issues. They weren't decided in favor of your client. I'm not sure what the appellate issue is here.
The appellate issue, well, there were multiple appellate issues.
I'm going to give you 30 seconds to answer that question because we are about double your time already.
The appellate issue is, did our client breach? The answer is no. Did Balski breach? Yes. The answer is yes. Were there excess damages well beyond any actual damages proved? Yes. So for all of those reasons, the judgment below has to be reversed.
Thank you.
Thank you.
People versus Randell Smickel. You may proceed.
May it please the Court, Anjali Pathmanathan on behalf of Mr. Smickel. Your Honors, I want to address two of the points in my brief below, the first being the DeBoer violation in this case, and the second being the excessiveness of the sentence. In this case, the officers violated Mr. Smickel's constitutional rights to be free from unreasonable searches and seizures. We have here 3 uniformed officers that seized Mr. Smickel at gunpoint while he was walking down the street and talking on the phone. This gunpoint seizure was a level 3 intrusion at the least, which required reasonable suspicion that the officers did not have at that time.
Why didn't they have reasonable suspicion? They had already received the radio run of a robbery. At least one of the officers believed that the robbery was with a weapon. And when they arrived at the scene, they saw a person fitting that description, and they had an anonymous pedestrian point to your client and say, that's him. Why is that not enough for a level 3 stop?
Yes, Your Honor, perfect. So the first thing is with the radio run descriptions, they were extraordinarily generic. So they described a person that was a tall black man wearing dark, nondescript winter clothing. That could involve any number of people in Midtown
Something
Manhattan.
else other than just black clothing, because if it was just that, I'd agree.
It was a dark pea coat or hoodie. That's dark clothing in the wintertime.
A peacock and a hoodie, both. They said the man was wearing both, correct?
Later, Your Honor, but in the radio run reports, it was an or, which ultimately is saying that he's wearing dark clothing in the wintertime. There's nothing like a bright color,
Didn't they
identifying
have that
shoes.
in addition to someone saying that's him? So they had the radio report, they had someone saying that's him. He was the only person on the street walking where they were looking for someone. There were a number of different factors.
Yeah, so the civilian, the unidentified civilian that pointed down the street saying that's him, over here, or that's him, the officers never actually verified any credibility about this person. I'm not saying that's irrelevant. What I'm saying is that gave the officers a level 2 common law right to inquire, right? They have a person who's basically the equivalent of an anonymous reporter pointing generally to where Mr. Smickel is walking. Yes, he generally fits a very general description. Sure, stop and talk to him. But these officers pulled up with all their guns drawn at this person, which is a level 3 seizure. And all they had at the time was a common law right to inquire. And that's where the DeBoer violation kicked in.
So are you saying that if a police officer is responding to a robbery where they believe a weapon is involved, they don't have a right to draw their weapon in this situation?
Yeah, correct, Your Honor. They can't automatically get a right to draw their weapon. And I also I contest that the officers knew that a weapon was involved because even the officer who said it was a, quote, strong-armed robbery specifically said on cross-examination, no weapon was reported at the time that they interacted with Mr. Smickel.
Okay.
So for those reasons, they didn't reach the level 3. I also briefly want to address the excessive sentence in this case because this was Mr. Smickel's first adult arrest. It's his only conviction. He has one youthful offender adjudication from 2008, and he was 25 years old at the time. He's been sentenced to 15 years in prison with 5 years of post-release supervision for a crime that's minimum sentence is 5 years in prison and 2.5 years of post-release supervision. There's no reason, there's no aggravating factors or reasons why Mr. Smickel, as a first felony offender, is serving over a decade more of time than the minimum sentence in this case. And I want to highlight one of the things that's most relevant to this point is that the sentencing judge was the same judge that offered him 7 years before his trial on the top count, so on the robbery and the first-degree count. We submit that this is the equivalent of a trial penalty here. He exercised his constitutional right to go to trial, and that sentence that was imposed after he went to trial was escalated by an additional 8 years.
What was the people's offer, the lowest offer the people?
I don't have that information on the record on appeal, Your Honor. I do know that the defense counsel at sentencing pointed out to the sentencing court that the court's last offer to Mr. Smickel was 7 years on the top count. Because it was.
Well, that's why I asked, because if
Yeah.
you say the court, that means the court was undermining the people's position. I just wanted to know by how much.
Certainly, I don't have that information,
Okay.
Your Honor. But I do submit that right now Mr. Smickel is serving 15 years in and 5 years after, which is 20 years of time that he's under control or supervision of docs for his first contact with the adult criminal, as an adult in the criminal justice system. And I think that submits an example of a young black man who's being subjected to mass incarceration in this case. There are no factors that attribute 10 years additional sentencing, prison time, on this case, Your Honor. And I submit that his sentence should be reduced to 5 years in prison and 2.5 years of post-release supervision in the interest of justice.
Thank you.
Thank you.
You may proceed.
May it please the court, my name is Patricia Curran and I represent the people on this appeal. The hearing court properly denied defendant's suppression motion. As the court has noted, there was a detailed description, a report of a robbery, and notably, the defendant was seen along the route that the robber was reported to have taken. Not only did a civilian tell the police he's over there and we're pointing to him, but the police also see the defendant crouch down when the defendant turns and looks at the uniformed officers approaching him and do something near a parked car. All of these factors are at least reasonable suspicion, and in fact, as the people argued below, they really are constitute probable cause.
Counsel, could you address the excessive sentence claim?
Certainly, Your Honor. The defense has asked that the court reduce the defendant's sentence to the minimum of 5 years. Below, the court sentenced the defendant to 15 years, where he could have sentenced him from 5 to 25 years. The court had, and this court should pay deference to that, the trial court had the opportunity to see these civilian witnesses testify. And I urge this court to watch the video here, because the sentencing judge had that opportunity as well. This defendant had a prior youthful offender conviction for a loaded gun. This was a premeditated robbery, and I don't mean premeditated, they looked down the street and they saw this woman. They were out in Brooklyn, and they planned this robbery because she had cash on her from the bus company that she worked for. And they specifically targeted her, saying, the defendant told us, because Asians don't fight back. All of these factors, including the injury to the victim here, which was not serious physical injury, but certainly physical injury, warranted the sentence here. And I had once again urged this court to watch the video here to see the practice.
What was the lowest offer the people extended to the defendant to plead out?
I don't know what the lowest offer the people offered. The court offered 7. However,
and at that time, what did the people want?
I don't know what the people wanted at this point. I don't think it's on the record that we have. Okay. But I mean, plea bargain offers are always lower before trial.
No, but this is double. This is the thing that, honestly, again, speaking only for myself, kind of makes me a little crazy. Because if pre-trial, it's worth 7, post-trial, if the sentence is double, that seems punitive. That seems like, oh, you made us work for this conviction, now we're gonna bang you. Well, and that's not what we're supposed to do here, right? That's not what we're supposed to do.
Well, the court specifically said below that he would never, ever, and I'm quoting, punish any defendant for going to trial. Now, once again, the difference between all of us and the sentencing court was that he saw these witnesses testify. If you watch the video, you will see the utter terror on the part of this victim when the defendant walks up to her and just casually grabs her around on the neck and shoulders and drags her slightly down the street. She didn't know what was going to happen. After the court saw these people testify, and her colleague came out and tried to help her, and she fought back, and then they came back again to try to rob her of the proceeds.
But when there are plea offers, I assume that the judge supervising the plea discussion also had familiarity with the case, or wouldn't be making an offer.
Well, Your Honor, but I think there's a difference between hearing what the witnesses might testify to and actually sitting there and listening to them testify. And also, a defendant shouldn't be sentenced to less than the offer. He should be sentenced to obviously more than the offer after trial, after there is absolutely proof beyond a reasonable doubt. And here, as we've noted in our reasonable doubt point, the proof was overwhelming that he was one of the people. It's all caught on the surveillance tape. So I urge you to watch the video before you make any decision about reducing the defendant's sentence. If there are any other questions about the other points, I'd be glad to answer them. Seeing none. Thank you very much.
Thank you.
Your Honor, just briefly, the point that was made about the statement, the Asian people don't fight back, that was not credited by the trial court below and therefore was suppressed from the evidence of this trial. So I submit that that shouldn't be part of the consideration of Mr. Smickel's character when we look at who he is and when we're looking at his sentence. The other thing that's important to point out is that, yes, there was subjective physical injury in this case, but as one of my other points in the brief show, there wasn't an objective level of physical injury here. So when we're talking about a robbery in the second degree or a robbery in the first degree, the level of injury that the complainant described doesn't reach the type of aggravated brutality that's described by the respondents. We look at a person who was asked if she needed medical attention. On the scene, she said no. She went home. She applied topical cream, I believe she said, that she already had in her house on a bruise. She went back to work the next day. It's not diminishing how she felt about the situation. It's not diminishing how scared she was about the situation. It's just talking about the level of harm that was caused when we look at how much time Mr. Smickel is actually serving for this. And at the very least, we submit that this court should at least reduce his sentence to the 7 years with 2.5 years of post-release supervision, which is what the court thought this case.
Why would someone who already has a YO gun and chooses, this wasn't a crime of circumstance or happenstance. Oh, I saw the door open, let me go steal something. This was a planned robbery at gunpoint. Why would we even think about cutting down PRS for someone who has done that?
Post-release supervision? Certainly, Your Honor. Well, I submit it's still his first contact as an adult with the criminal justice system. He's a first felony offender. And at the end of the day, we can't look at Mr. Smickel's life in a vacuum. We can't look at this crime in a vacuum. I mean, his life leading up to this offense was also something that should be taken into account with this sentence. He was a child of gang violence himself. He was exposed to gang conduct, drugs, and alcohol before he was even 9 years old. He'd been sexually assaulted himself. He was in ACS custody before he became an adult. I mean, his whole life was about getting out of poverty and trauma. And yes, he has a YO from 2008, and yes, he has been convicted of this crime, but at the end of the day, that doesn't mean that we can look at him exclusively in isolation of that incident. And at the time of this,
I'm not saying we should, I'm just,
and I think
PRS is good for people who don't have control.
I can't answer to control.
And someone
Your
who has
Honor.
bad judgment. If you choose to go and commit an armed robbery because this is an easy mark, okay? It just doesn't speak to me as someone who should not be.
Certainly, Your Honor. And having that position, it still means that his sentence should be reduced by at least down to 7, but we submit 5 years. With 5 years post-release supervision is still a much less excessive sentence than what he's currently serving.
Thank you.
Thank you very much.
People versus Raymond Reed. I am boiling up here. Oh my God. You may proceed.
Good afternoon, Your Honors, and may it please the Court. My name is Kenneth Crouch, appearing on behalf of Mr. Raymond Reed. The police in this case never had probable cause. The officers operated on a hunch. They followed a known drug user in their words, and they waited for something to turn up. Then they tailored what they said to prop up what they saw. But the account they came up with is simply inconsistent with common sense. First, let's start with the officer's narrative. The narrative of the pursuit doesn't add up.
I'm just going to interrupt you. Isn't the testimony that they actually saw the sale taking place and they saw the buyer approach with a $10 bill in his hand? Why isn't that enough?
Well, Your Honor, it's the fact that their narrative is incredible, that it's filled with
Why is that
inconsistencies.
incredible? What's incredible about that?
Well, certainly, Your Honor. So first, both the officers testified that the co-defendant, Mr. Ranucci, was a known drug user who'd been previously arrested for drug-related offenses in the same area, indeed at that very same bus terminal. They then testified that Ranucci held a $10 bill in hand for over half a block to the location here. Then the officers delayed their pursuit. They waited until they were at least 30 feet away from their targets. Yet they somehow closed that gap.
Okay, wait, so you're just saying the whole narrative. So the trial judge heard all that and made credibility determinations. And you're saying even though we have this record before us, we should overturn that determination because it's so incredible?
Yes, we are saying that, Your Honor. And speaking of the hearing court's determination here, I think their equivocation speaks to how close this case was. The hearing court acknowledged, quote, "I agree with counsel. I think there's an issue regarding the visibility of the bill in Mr. Ranucci's hand. Based on Herkenham's demonstration, it's possible he could have seen it. It's possible that Herkenham was inferring it was a $10 bill. That's on page 70 of the hearing transcript. So the court is discerning that the officers are presenting guesswork as concrete observation. And that very fact of equivocation speaks to how this ruling could have gone either way. Again, in looking at the officer's testimony, we're asked to consider that somehow a known drug user held a $10 bill over half a block and didn't bat an eyelash at a stranger peering at him from an elevated perch at a Dunkin' Donuts, only 5 feet away, according to Officer Herkenham's testimony. If there are no further questions, I'd like to turn to Mr. Reed's excessive sentence point. Mr. Reed received a 7-year sentence over a $10 sale.
The sentence, I'm sorry. Can you deal with the Crawford violation that you're claiming?
Well, for the purposes of argument, Your Honor, we're just simply addressing the excessive sentence and the Fourth Amendment. Oh, I'm sorry.
Oh, you don't want to, okay.
For the purposes of argument, we're addressing the excessive sentence argument and the suppression point, Your Honor.
Okay.
So just very briefly, Mr. Reed received a 7-year sentence for a $10 sale. This case was a minor sale, but because of a prior 1999 conviction and because of New York's sentencing regime, it mandated a minimum of 6 years in this case, which is in itself an inordinate amount of time for a $10 sale. And further, a 1-year reduction in this case wouldn't thwart the rehabilitative aims of incarceration. if this court is concerned about his recovery outside of prison. He still has state supervision for 2 years. Additionally, our office has staff resources to support his reentry. And he's already proven that he possesses the ability and the desire to achieve stability and productive membership outside of society. He transitioned from the shelter system to permanent supportive housing. He obtained his GED. And even while awaiting trial in the present case, he completed a range of FedCap programming from reentry to employment skills to mental health and first aid training. So if there are no further questions, Your Honors, for the reasons stated in point 1 and point 2 of Appellant's brief, we ask that Mr. Reed's conviction be reversed and a new trial ordered. For the reasons stated in point 3, we ask this court to reduce his sentence to the minimum permissible term. Thank you.
Thank you. You may proceed.
Good afternoon, and may it please the court, Jennifer Westwell for the people. The hearing court properly denied defendant's motion to suppress the drugs and money recovered from him after his arrest. Furthermore, defendant's guilt of criminal sale and possession of a controlled substance was proven beyond a reasonable doubt. Furthermore, his Confrontation Clause claim is entirely unpreserved for this court's review, as he concedes on appeal. Regardless, the claim is without merit, as Ranucci's statement was not testimonial in nature. Finally, defendant's sentence, which was only slightly above the minimum.
So I'm going to ask you a question about the Crawford violation. When you say that the statement, it was the statement of the co-defendant, right?
Yes, Your Honor.
Right, and that statement it was an exception to hearsay, it was an admission?
So,
just bear with me, right? I'm going to get to the Crawford part of it, next question, all right? Right, so it was admissible hearsay subject to an issue of Crawford, right?
Correct.
And the inquiry on Crawford was that statement by the co-defendant testimonial, right?
Correct, Your Honor.
All right, so was that statement taken when the co-defendant was in custody?
I'm sorry, can you repeat that?
Was the statement taken when the co-defendant was in custody?
Yes, Your Honor.
Okay, and was there any interrogation going on at the time?
No, so the record is entirely silent as to what, if anything, officers Herkenhem and Masiana actually said to Ranucci, if there was anything that even elicited that statement, which is why it's so important that this is unpreserved, because counsel below never objected, it was never seen as a problem, and he never developed the record to even find out if there was any conversation that happened before that.
But because if there was any interrogation, that might impact on whether it was testimonial or not, correct?
Yes, Your Honor.
As opposed to a completely voluntary statement.
Yes.
Okay, thank you.
I'm sorry. If there are no further questions, I respect.
What say you on the reduction request by a year?
Defendant's sentence, which was only slightly above the minimum and is largely impacted by his violent criminal history, was fair and appropriate.
This is nothing more than I am a drug addict. You and I both know it. This is not a, he's a drug addict.
I don't know that I entirely agree with that, particularly given the sodomy count on the 2-year-old. Also, there are further escalated.
On this case?
Yes. It was, I think it was like around 2,000. That was the violent felony offense that we had asked about for Sandoval.
Okay. I don't understand what one has to do with his drug addiction, but okay. All right. You have 1 minute.
Your Honor, just very briefly, I'd like to address some of respondents' comments. I think Davis versus Washington, which was adopted by the Court of Appeals, and People versus Rawling, says that statements made in the absence of an interrogation aren't necessarily non-testimonial. And to be clear, the record is ambiguous about whether or not there was an interrogation here.
But didn't you have to preserve it so that the record actually could be developed about whether this was in response to, exactly how this statement came about?
Yeah, well, we asked that the court reach this matter in the interest of justice, but again, it's clearly ambiguous. There's no indication, there's an indication there was a conversation between the officer and Mr.
Right,
Ranucci.
if it's ambiguous though, and that's your best, how can we rule that it's testimonial?
Because, Your Honor, this is Mr. Reed's confrontation right, and that these are the sorts of constitutional rights that we preserve and hold dearly, and I think, given the magnitude of that right, should still be reached. But more importantly, I just want to reach, Your Honor, just regarding respondent's brief saying that the earlier suppression point is unpreserved. Just very quickly, on page 67 and 66 of the hearing testimony, defense counsel specifically requested suppression of the physical evidence, given the credibility of the officer's testimony.
Thank you.
Thank you, Your Honor.
All right, matter of Brienne T. That's submitted? She's coming.
3 and 3.
You may proceed.
Thank you, Your Honor. Good afternoon, and may it please the court. Shanae Brown for the Bronx Defenders, appearing for respondent appellant, Mr. G. The crux of this case is the credibility of the child's allegations. Mr. G is facing very serious allegations, and his defense is that the allegations are not true.
Counsel, it seems to me that you're relying a lot on an alleged false allegation by the child when she was 4. I have a lot of questions about that. My first question about that is, when I looked through the record, the only thing that I could find that supported that at all was a single sentence that said, source said mother did have concerns whether child was telling the truth, as she has lied in the past about being abused by an uncle. Is there anything other than that that you're relying on?
Yes, Your Honor. With regard to the mother's statement regarding the prior false allegation, and based on the constellation of information in the record.
And where is that in the record?
That's a progress note that we received.
I'm sorry?
That is an ACS progress note that we received from ACS.
That's what I just read from, was from the progress notes.
Is
there something other than what I just read to you?
Yes, it's a different page in the progress notes where the mother, even though it's not in the record, but it was cited by...
It's not in the record.
But it was cited...
Okay, but we tend to focus on what's in the record.
Yeah, my apologies, Your Honor, that note was included when we attached it to our motion. But the mother indicated that Brienne has a tendency to lie, and in the
As a tendency, or had lied once before?
Yeah, now we've gone from she told one lie about a uncle touching her leg, because that's all the allegation I saw. Nothing other than touching her leg, which in and of itself is not sexual, right? That's it. So how do we get from she took back the statement, my uncle touched my leg, to now she has a tendency to lie?
Well, on that same page where it says that the prior false allegation involved leg touching, on that same page it says the mother stated her daughter has a tendency to lie.
And that's a page that's not in the record, right?
Yes, that was something that was...
That's a problem.
My apologies, Your Honor, but that was something that was cited in legal aid's brief. And so that's what you read when you saw about the leg touching.
Okay, but are you claiming that the alleged incident about touching the leg happened when Brienne allegedly was 4, right?
Yes, Your Honor.
Go ahead,
and then,
continue.
and we believe that the prior false allegation...
So if the child made an allegation when she was 4 that she then recanted, how is that relevant to her ability to tell the truth or report accurately when she's now 12?
Yeah, so what's central to our defense is the reliability of the allegations.
I understand. How is what she said at 4, do you have any expert evidence, expert testimony that what a child does in terms of truth-telling at age 4 has any relevance to the child's understanding of truth when the child is 12?
That's what we're trying to get. We're trying to get a clear understanding of the context and circumstances in which she made the allegations then, and whether those same circumstances exist now that may have led her to make this current allegation, which we believe is false, and that she may have a tendency to lie.
And you think that you need 12 years of therapy records in order to do that?
Yes, we do. We believe that the information contained in the mental health records will speak to the credibility of the allegations, whether her mental health status, her stability, the therapist's impressions, whether the observations of the therapist or any other mental health issue may impact her ability to tell the truth.
Do you have any basis for believing that she was diagnosed with a mental illness that affected her ability to tell the truth?
We don't know that for sure, but based on because our defense, the allegations in this case, the credibility allegations, goes to the heart of this case. And we believe, based on the information that we've received, that Brienne may have a problem with truth-telling, and that may be a broader issue that may have led to why she made this allegation against Mr. G.
All right, you'll have time on rebuttal.
Thank you, Your Honor.
Good afternoon, Your Honors. I'm representing the child who's now 14. And I just wanted to just clarify one thing. Where this case has not gone to fact-finding, there isn't a record where things have been entered in evidence. The record consists of the documents that counsel for appellant has presented in motion practice and those that our office did. So it's not accurate to say something that's in the record. However, what was presented by counsel for appellant were hospital records from the day that the child was examined after making allegations.
On this case?
Sorry?
On this allegation?
On this allegation. There was never anything to do with when she was 4. The progress, and the other thing that appellant relies on is progress notes, which were very sort of cryptic at this point because they were from the day 1 of the investigation. And the record, but it did show, both in the ACS progress notes and the hospital record, that she began therapy in the past, at some point in the past, and that it was believed at the that she was acting aggressively, and that whenever that happened, they believed that it was associated with her having witnessed domestic violence. There's absolutely no basis to tie the allegation she made when she was 4 with therapy that she underwent at New York Presbyterian Hospital at some point thereafter, which ended a year before the allegation made in this instant case.
Can you tell me whether...
It just wasn't clear to me in the...
I'm sorry.
It wasn't clear to me in looking through your brief. Do you have any objection if the court holds an in-camera inspection of the child's records and then decides whether they should be disclosed or not?
I will not speak for the trial attorney because I'm not, but this was
Sorry, can you repeat?
a reasonable, that would have been a reasonable thing, but appellant never even suggested that that was the way it should be done, which is the way it is done. In Dean T, this court absolutely
So
said.
nobody raised it below?
Pardon?
Nobody raised it below, is your...
No.
And
They never alleged that they wanted that.
I'm sorry, I didn't hear. Did you say you do or you don't have an objection to it, though?
I said I hesitate to say it definitely because I'm not the trial attorney. And I think that particularly the NYP records from long before this are absolutely, there's no basis to ask for those records. In terms of the current records.
Follow up on what you, in terms of the current records.
The current records.
I have a question about that. Did you put in any evidence from the child's therapist or anyone else about what the effect would be on the child?
Yes.
Of having those records reviewed, even by a judge?
No, not that part. I'm sorry. What the therapist said in her affidavit accompanying the responding papers was that it would be detrimental to the client-therapist relationship and undermine the trust fundamental to the therapeutic alliance were the records to be disclosed. It was not couched in having an in-camera inspection, which was never mentioned.
Has this child been asked about this issue? Is she aware that this is her stepfather, correct?
It's the father of the two youngest children.
Right,
Yeah.
so her stepfather, for lack of a
Yeah.
better word. Is she aware that her stepfather is trying to get her mental health records? Is she aware of it? Has she voiced an objection to it?
Personally, herself, I only know.
Has she told her lawyer?
I am not aware of that. I haven't asked the trial attorney.
You would think you would have asked that question. I mean, that is the question.
It was manifest that this was something that was disturbing to her. But in terms of the ins and outs of the motion practice and how that, I know they have, there's definitely, there's been nothing done that was not explained
To her.
to the
Okay.
child.
All right.
But it's, it's almost a axiom that interference or
I understand, trust me.
it's always been something that makes the courts stand back and say, this has an awful lot of damaging potential and has mostly been found to have, without much ado, to outweigh any argument by the accused person to demand access.
Thank you. Counsel, you have a minute.
Counsel, I noticed in your brief that you cited the Second Department decision in Elliott PNG, but in that case, the court affirmed the denial of production of records from the child's current treating therapist, even to be reviewed in camera. So whereas it approved the disclosure of other records, but not the child's therapy notes. Doesn't that harm your case?
With regard to the New York Center for Children records, we know that's an issue of concern, but the statute, the Family Court Act, contemplates issues like this one, where the respondent needs the records for the preparation of his defense.
But the only, as I understand it, the only indication you have that this child has any history of not telling the truth is this incident from, I guess, what's now a decade ago. So is that the only thing that you have to go on to support your claim that you need to look at the child's current therapy records in order to present a defense?
No, it's not just the prior false allegation, even though we believe that when we read that statement that the mother made, that speaks to that alerted us that maybe something was going on with Brienne. Maybe there's a broader pattern here that she has with telling the truth. And based on the constellation of information we received in the case, we believe our defense goes back to the heart of this case.
But what do you have to rely on besides the mother's statement about the incident 10 years ago?
The other statement that she made, that she has a tendency to lie.
I see.
And we believe that if the child has a tendency to lie and she regularly lies, then we need that information for our defense. And that speaks to the credibility of the allegations, because we're saying the allegations are not true and that Brienne is not a reliable reporter. She has issues with telling the truth, and we need to get a better understanding of the context and circumstances of what led to the prior false allegation, what may be leading to her having a tendency to lie, and what may have led her to.
Is the statement about her tendency to lie attached to your motion papers?
It isn't attached to my motion papers.
What is it attached to? I couldn't find it. I looked really hard. Can you tell me, can you give me any guidance about where to find that?
It's referred in a progress note that ACS provided to us. And it's on the same page where.
Is it in any of the motion papers before us or anything else before us?
It's not in the record, but that was something, it was on the same page where it was mentioned about the leg touching.
One quick thing, sort of following up with that, I'm sorry. The respondent lived with the child for a period of time, right?
Yes, that's correct.
After she was 4 and through the time that she was 12, right? I mean, he knew her pretty well. He was an adult responsible for her under the law, right?
Yes, my understanding that he was
there's
living in
no-
the home.
There's no affidavit or anything from him indicating that over the years that he's known her, that he has observed her lying. Is there?
We have not seen that. We're just basing what we're saying that goes central to this case and what's central to our defense is that there may be something going on with this child that reflects a broader pattern of her capacity to tell the truth. And so that's why we believe that the mental health records will contain critical information for our defense.
Understood.
Thank you.
Thank you.
Thank you.
Vargas versus 1166 LLC. et al. You may proceed.
May it please the court, Alex Warwick for the plaintiff appellant. Your Honor, the plaintiff fell 5 feet off of a scaffold that he said had no rails. His co-worker who came up to the scene of the accident while he was still there confirmed the fact that there were no rails on the scaffold and that there were no rails anywhere. And in fact, only about
What's the name of that co-worker?
Velasquez.
Okay. Go ahead.
And that only 1 out of 5 of the scaffolds on the site on the 20th and 21st floor where the work was being done had rails. The only opposition to this evidence, which is a prima facie showing of entitlement to 240 liability, are affidavits by Mr. Laura, who's one of the supervisors, and Tissio, another supervisor. Laura got there 1.5 to 2 hours after the accident, and Tissio got there after plaintiff had been removed from the building by the ambulance. Neither one was...
Let me ask you a question. At the time of his fall, the plaintiff here was taping, correct?
Taping, yes.
Okay, and he wasn't taping the ceiling because the scaffold wasn't that high.
It's 5 feet, about 5 feet high.
So what he was taping would have had to be a wall, correct?
Yes.
Okay, so that if my review of the record and the evidence is that these affidavits talk about the scaffold being in the middle of the room when they come to the accident site. That's not where the accident happened, right?
No, I think they may have been talking about the photograph that the plaintiff took of the scaffold the day before. As a matter of fact, that was the one he used that day, but on a different floor. A photograph because it showed a condition of that was he considered dangerous because of some wires. It's in the record.
So on the day of the accident, the photographs, there was someone who took photographs, correct?
Yes, photographs were taken allegedly, although they were not part of the affidavits, and no mention of them.
And they're not in the record?
Well, they're in the...
Are they in the record?
There are photographs of the scaffold that the plaintiff took. There are photographs that show that the feet on the scaffold were unlocked, but no photographs of any rails that they claim were nearby a wall where the plaintiff was working. Oddly enough, those go unmentioned by anybody, by Laura and Tissio in their affidavits. They're unmentioned in the briefs. There are no photographs. You would think that if there were, that would be the focal point of their opposition. There were no witnesses to this accident. As a matter of fact, Laura testified, he said in his affidavit, there were rails nearby.
I thought the claim was that the rails were on the 21st floor and the accident happened on the 20th floor. Am I incorrect about that?
The accident is on the 21st floor. The rail, there were,
I thought it was the other way around.
Velasquez said there were no rails anywhere on the 20th or 21st floor. Laura, when he testified in his deposition, was asked, did you see any rails near the accident? I don't recall.
Right.
Twice,
Didn't someone say the rails were on another floor? One of the defense witnesses state that the rails were available on a different floor?
That's not my understanding. My understanding is that they claim that the rails were nearby the scaffold that the plaintiff was working on, although that is just, there's nothing in the record to show that. They came upon the accident, as I said, well after it occurred. They claimed to take photographs, and there weren't any, oddly enough. And they're, having not been witnesses and having come upon the accident scene after the accident, their opposition does not amount to a rebuttal of plaintiff's prima facie show.
But my question was, is there a photograph that purports to show the placement of the scaffold when Tizio and Laura come to the site?
No, not that I'm aware
There's
of.
no photograph post-accident?
Only of the scaffold, as far as I'm aware of, that the plaintiff took on the 20th floor, where he was on the 21st floor at the time of the accident.
Okay, all right.
Thank you.
Okay, who's next? And who are you here for?
Hi, I'm the respondent. I'm here for 1166 in Veris,
Okay.
the owner in GC.
Okay, so you have 3 minutes.
Right.
Okay.
Well,
you may proceed.
logistically, there are 2 appeals, so I'm not sure if it's 3 minutes for both, or, but nonetheless.
Start talking. You're
start
eating up
talking.
your time.
Okay, gotcha. All right, so all these items about not taking photos, that's that's arguments to make before a jury. The court's role here is issue determination. And issue determination, the court has to take as gospel Mr. Tizio's sworn affidavit.
Why?
Why?
Why do I have to take it as gospel?
What do you mean? What is gospel?
Okay.
What kind of argument
Excuse
is
me?
that?
Well, he sets forth that for all the Baker scaffolds, guardrails were distributed with those Baker scaffolds.
Well, you know what I found really interesting about some of the affidavits here? They, on the one hand, say, oh, we always send guardrails for every scaffold we have on site. Every single scaffold has enough railings on site. But then in another sentence says, if he had complained, we would have gone back to our shop and picked up more. So which is it? You have enough on site? Or if there's a complaint, I got to go pick some up. That, to me, kind of really seems like conforming a statement to avoid summary judgment.
No, that is in the event, for whatever reason, if there was a shortage, because guardrails are purchased separately from the Baker scaffold.
But why would there be a shortage? He said in his statement, it is our practice, and my supervisor said that that's what was done here, that we always deliver enough guardrails for every scaffold we have. So his next sentence, that if there had been a complaint, we could have gotten some, seems to fly in the face of that absolute firm assertion.
Isn't that an issue for the jury? Doesn't that just go to credibility? I mean, if we take what he said, there were guardrails.
All a defendant in a construction labor law case has to say is, we had them there, and that's enough?
We had them there. When he got to the scene, shortly thereafter, while this guy was being loaded into the ambulance, he saw the guardrails on a nearby wall.
That's interesting, because did the ambulance come to the 20th floor?
Yes, it
How
happened.
could he have seen guardrails as he went into the ambulance when the ambulance is outside and these guardrails are in the building? No?
The accident happened on the 21st floor.
Right. So how does he see the guardrails at the same time he sees him getting in
Well,
the ambulance?
all right. When he got to the scene of the accident was when he saw a plaintiff. When he got to the site, he saw a plaintiff getting into the ambulance, is what I should say.
Right. But
when he
has
first got
two
to the
diff-
site,
Counsel, you know, there are contradictory statements by some of your witnesses. And I've only just started looking at the record.
well, that's for the jury to decide who's more credible.
Oh,
If a jury believes,
we shall see.
if a jury believes, if I may just say, if the jury believes what Mr. Tessio says, the elements for sole proximate cause was met. The wheels were unlocked. He didn't use the available guardrails, and when I came to the scene shortly thereafter, I saw guardrails leaning by a nearby wall, and throughout the site, if workers took off the guardrails to fit the Baker scaffold and elevator, there were guardrails kept on the 20th and 21st floor. This is an open floor layout. You could see them leaning up against the wall, that there were no
Yet we
shortages.
have no picture of them. Thank you.
That's also a credibility argument for the jury. That's for
Thank you.
plaintiff to argue to the jury.
Counsel, there's no question in front of you. Thank you.
Good afternoon.
You may proceed.
Alan Russo, Russo and Gould for the third-party defendant Precision. We're an appellant and a respondent. So I'm sort of like in between the two of these arguments. Well, my argument's going to be the same for both. Clearly, under the facts of this case, as they're presented in the record, I heard from the questions the court asked both attorneys, there appears to be some confusion. And there appears to be contradictory evidence. And I'll highlight that on all of the issues as they impact my client. First of all, let me make it this simple. The plaintiff's claim is that there were no guardrails on the scaffold at the time he fell. That's his claim. He also claims there were no guardrails on the site whatsoever. That's his claim. He also claims he was not
Did he
surfing.
say that? That there
Yes.
were no guardrails whatsoever anywhere?
That's what he said.
Okay.
He also said that he was not surfing, in quotation marks, at the time of the accident. Those are his
There's no
contentions.
evidence of that.
Well, the evidence is that his coworker, Mr. Velasquez, told the union representative when he got to the site that the plaintiff told him he was surfing at the time he fell.
Well, that's hearsay, so that's not direct evidence of anything.
And also, didn't Mr. Velasquez deny having said that to the union representative?
There's some contradictory evidence of that, okay?
Right.
So that's what I mean. This
So he
is
denied
part of
it.
the dispute. But what he didn't deny, he directly contradicted the plaintiff. He said the wheels were not locked on the scaffold. Why is that important? It goes directly to the issue of the plaintiff's credibility.
Well,
The plaintiff swore.
let's
Okay.
on the issue of the wheels not locked,
Mm-hmm.
that would not have been the only reason someone would fall off a scaffold, right?
Correct.
So that even if that were the only issue here, that those wheels wouldn't help you because there's no guardrail.
If that were the only issue, but where the issue is clearly the credibility of the plaintiff, the fact that he may have lied about a material fact in the case goes directly to his credibility. And that's why we have juries. And that's why, in part, I believe there's plenty of factual contradictions in this record. As the court noted, there were two witnesses who submitted affidavits saying that there were guardrails on the site. Direct evidence. One, Mr. Tizio, who was I believe he was the foreman on the project for Precision, said there were guardrails for every scaffold. There were brand new scaffolds. All the wheels worked. We inspected the scaffold after the accident. There was no problem with it. It was a brand new scaffold. And he specifically, he specifically said that he saw guardrails, I think, leaning against the wall.
Who said this?
Tizio.
Tizio, yeah.
Okay, and he's the foreman.
Did he say that from the very beginning?
Yes.
Really? Okay.
We then have the vice president of Precision who came
Well,
on.
he saw nothing, and he took back what he said at deposition, so.
Yeah, but what he did say.
That's a wash.
What he-
Everything he says is all hearsay.
No, it's not hearsay. He specifically at his deposition said, I saw guardrails in the open area of the floor. This is a big space. So the equipment was there. The plaintiff, the defendants argue, just chose not to use it. That's what the factual defenses are in this case. So here we have plaintiff says no guardrails, and there were never any guardrails, which seems also incredible. He also says, which is interesting, this goes to credibility. The day before, he took, by the way, he was the shop steward. He took a photograph of the scaffold the day before to show that the flooring, there was cables in the area of the scaffold. On the scaffold he was working on the day before. And plaintiff presented that and is using that to argue this is an generally unsafe work site. Well, if there were no guardrails, he's a shop steward. If there were no guardrails for any scaffold on this site, he would have been the person to report it. It is simply incredible. He's also
He was an extra on this job. Isn't that correct? He wasn't actually part of the team. He was an extra taper who was brought in by the union. So he's
Yes.
not a shop steward at this site because this wasn't his job site. He
I
was
know,
an
but
extra that day,
yeah,
correct?
but part of what a shop steward does is report unsafe work conditions. He's also asked at his deposition. This also goes to the issue of credibility.
All right, let's wrap it up because you're out of time.
Okay.
Go ahead, finish your thought.
All right. He's asked at his deposition about, were you surfing, scaffold surfing? Everyone here knows what that means. He's a shop steward. He said under oath, I have no idea what that means. Now, what does that tell you? It tells you he's not very credible. And that's why we have juries, and that's why we have trials, and that's why the motion for summary judgment by the plaintiff was properly denied.
Thank you. Counsel, you got 2 minutes on rebuttal.
He didn't say that he doesn't know what surfing means. He said, I didn't surf. I've seen it, I've heard it, I don't do it. There's no evidence that he was surfing at the time of the accident. And I've cited several cases from this court that the issues of surfing and whether the wheels were locked involve comparative negligence questions, which are not defenses to a label or 240 sub 1 cause of action. The proximate cause issue, if he were surfing, if the wheels were unlocked, there were no rails.
How do we get past the defendant's witnesses who have submitted affidavits saying there were scaffolds, guardrails on site?
On the site, the law is very well
On
settled.
the floor. I mean, you've got one person saying it's right on the same floor he's working on.
Again,
So how do we deal with that?
if we're talking about Laura, one of them, he came there an hour and a half to 2 hours later,
Right.
so it's very possible.
How about Tizio?
Tizio was not there at the time of the accident. He came up a good half hour or more after it occurred. He wasn't there. He doesn't know what happened between the plaintiffs being taken from the floor down to the lobby and then into the ambulance to the hospital. He doesn't know what happened in that time period from the time of the accident.
But
So
can
he
we ignore the fact that he claims that there were guardrails on the same floor where the plaintiff fell? Can we ignore that?
Yes, he's not a witness to the accident, and it was made post-accident.
But it's not about the accident, it's about what's on the floor.
Well,
He doesn't have to see the accident to testify, when I got to the accident site, there were guardrails right there he could have used.
for the very reason that he got there sometime after the accident, we don't know, and he doesn't know, whether the rails were placed there for some reason by somebody else after plaintiff's accident.
Are you conceding they were there?
No, not at all.
Okay.
We have the plaintiff's and Velasquez's testimony that they weren't there. And I would add that plaintiff, be shop steward or not, he did ask for rails, and he was told they're coming. He asked twice, he said, and he didn't have them, so he had no choice but to work without guardrails.
Okay, thank you. All right. Go ahead.
Yes, I'll try to be very brief. I didn't address my cross appeal.
You've got 2 minutes.
So I'm going to address that right now. Same issue. There are factual disputes to preclude summary judgment on behalf of the defendant on a contractual indemnity. The law in the state has been clear for,
Counsel,
I don't know,
let me
40.
ask about that, because the whole discussion up till now has been about 240. But for the contractual indemnification, for it not to come into play, you have to show some negligence on their part. Are you still trying to argue that even though the court dismissed the 200 claims, that the negligence claim shouldn't also be dismissed, that there's some distinction between a 200 claim and a negligence claim?
I'm not arguing the negligence claim should be dismissed. I think there's a factual dispute.
No,
When it-
why shouldn't they be dismissed? Is my point to you is if the court below dismissed the 200 claims, why wouldn't those negligence claims go hand in hand? Because there's legion of case law that 200 claims are identical to negligence.
Because in the plaintiff never addressed the 200 claim in its motion, opposition in its motion.
And oppose it.
He didn't oppose it, right.
So if he didn't
It
oppose
was
the
never
200,
decided
he
on
also wasn't
negligence.
opposing dismissal of the negligence because they're the same thing.
Yeah, but we never got to that issue on behalf of the defendant.
Well,
with
why
regard
shouldn't
to the
we get to
contractual
it in
indemnity claim.
determining the contractual indemnification claim?
Because if you believe the plaintiff's case, which I don't, but if you believe it, then this job site, according to Tizio, according to the plaintiff himself, was like the Wild West. People were surfing, scaffold surfing, all throughout the site, and there were no guardrails in any of the scaffolds.
So that's a 240 claim, now that's not a negligence.
I understand that, but that goes to negligence. Forget even 240 for a minute. I mean, I think
Okay, you
it
still
would be
haven't answered
negligent
my
to have
question.
people working at a
Counsel, you still
height
haven't-
without
You
guardrails.
haven't answered my question, which is, are you trying to argue there's a distinction between 200 and common law negligence?
There may be no legal distinction, but it does not, but it is, there may be no legal distinction, but in this particular case, we never had it. There was no, first of all, there's no establishment of our negligence to trigger the violation, number one. And secondly, if the court does believe that there were no guardrails supplied, that there was unsafe activity on the job site, the defendant, by his own admission at deposition, said they were actively engaged in enforcing safety on the site. And indeed, if they saw someone scaffold surfing, they would literally stop that person from doing it. So they were actively involved in enforcing safety. So if this court or jury finds that they were involved, they didn't require any guardrails on the site, by those facts alone, they may establish a negligence claim against the defendant and the owner.
Okay,
So,
thank you. We're done.
okay,
All right.
thank you.
Guys, yeah.
Come on up. You got 1 minute.
I didn't ask for time.
Next time, you have to make this argument when I'm asking you for your time. You didn't, I'm giving out time. and
Okay,
you
I
said
thought it was two, I thought it was separate, because there were two separate appeals, so I figured.
It's one case,
Okay, all right.
okay?
When I was up here before, it was just in
1
response.
minute.
Okay,
We don't double count appeals here.
okay. Oh, thank you. Oh, sorry. All right, well, I would just say to that is the court dismissed the 200, made my prima facie case. The contractual indemnification clause is an arising out of clause, not a proving acts or omissions of precision. And worker, Precision owned the Baker scaffold. Precision was responsible for supplying the Baker scaffolds with the equipment. And the case law in the First Department is legion that accidents arising out of a subcontractor's equipment is a means and methods analysis, not a condition premises analysis. A contractor's general supervisory powers to stop work on an unsafe condition is just mere general supervision. And there's plenty of case law, which I cite in my brief, which holds that as true.
Thank you. Baychester Retail versus City of New York. You may proceed.
Good afternoon. May it please the court. Mackenzie Fillo for the city. This court should reverse because petitioner's claims are unripe and unexhausted. If you want to sue, you have to have a concrete injury, and the petitioners don't have one because their permits have not been revoked. And if you want to sue over DOB taking your permits, you have to appeal to BSA first. These are very straightforward principles that can't really be disputed. The petitioner's entire argument seems to be that this prior litigation that this court, that some of the justices of this court ruled on, involving this gigantic sign that was about 27 panels, that somehow this court was deciding the distance from the New England Thruway. And you only need to read the decision to know that that is not what was at dispute in those cases. The petitioners...
And assuming for a minute, because your argument is basically that it should go through the regular channels of procedural administrative review, right?
That's exactly right.
So, and would we have a different record?
I'm sorry?
Would we have a different record?
That's exactly right. The key part of this case is not in the record here, which is the city map. All we have is a letter from city planning saying what it believes the city map from 1948 shows. But there's really no way for any of us to confirm or deny that what is in the letter without the map itself. And
And,
certainly,
and since this case has been pending and this appeal has been pending, have the permits been revoked?
no, because the petitioners got Supreme Court to issue an injunction preventing the Department of Buildings from doing it.
Them.
So this
Okay.
is, I mean,
Okay.
just really
Understood.
delaying the resolution of this case by coming to court instead of doing the normal administrative procedure, which every property owner that has signs is required to go through. All that DOB did here was issue a letter of intent to revoke permits and say, please come talk to us about this. DOB issues hundreds of those letters every year. If this court wants all those people to sue instead of going to BSA first, then I guess it could affirm. But if it wants people to go first to BSA, as they're supposed to do, then the court should really reverse and make the petitioners go through the normal procedure that everybody else goes through.
Right, and then we would have a fourth appeal about this sign, right?
I mean, well, maybe BSA will
I'm
agree
being
with them.
glib. I take that back. It's not a question, really. But we would.
Yes, but also BSA may agree with them. There may
maybe
be,
rightly.
city planning could, in theory, be wrong about the map, or
Right,
BSA could
maybe we
grant
need the
a
map
variance.
to rule on it.
Right, exactly. There's many reasons that appealing to BSA could prevent this court from ever having to decide the issue.
Thank you.
Thank you.
Good afternoon, Your Honors. Jason Sorolnik on behalf of the respondents. The reason why what you just heard is not dispositive here is because this is not a question for this court to decide as to whether or not the city map says something or supports a particular conclusion. Justice Rackauer's decision here.
Sure. Why isn't, we don't have a determination yet. As she said, they might decide, we're not going to revoke. We agree with your argument. No determination has yet been made. So why should the court make a ruling on this before any determination has been made?
Two reasons, Your Honor. First of all, there was a determination that was made. A final determination was made by the DOB to revoke these signs. It has not been implemented in response to Your Honor's question because the Supreme Court.
Even assuming you're right about that, we still have to go to the BSA and do an appeal.
Your Honor, we don't have to go to the BSA. The reason that Justice Rackauer found that we don't have to go to the BSA is because the legal question that was presented to her was whether or not doctrines of estoppel prevent the DOB and related parties from the city from forcing us through the same mousetrap that we've been through for a decade. Here we have litigation that I would venture to say we've never had. We have a litigation history where this issue was presented and decided by the DOB, the BSA, and the courts.
Well, was it decided or was it assumed? I mean, because the issue that seems to be at play here is the distance of the sign from the highway. And while there were certain assumptions apparently made in the two prior proceedings, why is that dispositive? Why was that actually litigated?
Your Honor, the answer to that question is twofold as well. First of all, yes, it was decided. It wasn't assumed. The record is replete with the evidence that went through hours and hours and hours worth of hearings on this very question. Just so that the panel can understand, the question of where the highway ends is the very first question that needs to be addressed before any of the calculations that were presented to DOB, BSA, to the courts below, or to Your Honors. In order for those to get off the ground, you need to know point A, where does the highway end? That question was resolved in a resolution by the DOB, by the BSA, 322 feet from the edge of the concrete at the highway. That was decided by 4 different agencies, the DOB, BSA, and various commissioners. It was then the premise, the predicate of the actions that were brought to the courts, and the courts reaffirmed each of those calculations. That, Your Honor, is the first answer to your question. They were decided decidedly with extreme evidence and attention paid to the question, the threshold question of where this highway ends. Everything else can't be calculated until you have that basic fact. And we have a very clear record on that. But beyond that, Your Honor, what the city entirely ignores in their brief is the second response to Your Honor's question. There was a specific proceeding in 2018 to 2019 where there was an audit on this very question with respect to these very permits. In 2018, the city tried this already in a slightly different way. And they said, maybe we want to revisit where the edge of the highway is. And they went through an audit, and there was a final determination that the attempt to move the edge of the highway again failed. That was the final determination as to the record, I think it's 575. And that final determination presents race judicata problems independent of the three other estoppel doctrines, all of which Justice Racco relied on in issuing the declaratory relief that she issued. Race judicata, Your Honor, applies regardless of the question of whether or not DOB assumed it, decided it, investigated it. The truth of the matter is they investigated it up the wazoo. They tried as hard as they could to deny these permits. So as a factual matter, the record is replete with evidence that it was not assumed. But it doesn't matter. For the race judicata doctrine to apply, there need not have been actual litigation of the claim anyway. Race judicata, as Your Honors all know, applies whether or not a claim was raised, as long as it could have been raised. They were examining this very issue for these very permits, and if they decided for whatever reason that they weren't going to raise this argument, that is on them. The doctrine of race judicata, which is a pure legal issue that was presented to Justice Rackower, says whether or not you raised it is not the issue. If it could have been raised and you didn't, and there was a final decision, and here there was a final quasi-judicial decision that all of the cases, including the Waylander case, recognizes, all of the cases say counts for collateral estoppel, race judicata, and judicial estoppel. Here, we had a final determination in 2019 that said we cannot move the edge of this highway. So if they came up with a new argument now, that is exactly why we went to Justice Rackower for declaratory relief. The question before the Justice, and I realize my time is up.
I'll allow you, go ahead.
Thank you. The question before Justice Rackower was straightforward. Do we need to go through this same mousetrap again after a decade of trying to comply and using the BSA's rulings and Your Honor's the court's rulings to inform how we are going to invest in this property and comply with the law? Do we really need to start over again because a new argument was devised by somebody at the DOB to try and take this sign away from our clients again? And the answer to that question is decidedly no. 4 legal doctrines preclude us from trying to revisit the merits. And so we don't need the city map because we're not asking Your Honors to decide any factual question. We didn't ask Justice Rackower to do that. Justice Rackower decided the question of legally whether or not we can get back into the merits because this decision was already made, and 4 separate legal doctrines say no. Thank you for the extra time, Your Honor.
Counsel?
First of all, they are asking for a factual determination. They say in their petition very clearly they're asking for a declaration that their sign is 322 feet from the highway.
Which was a prior, he's saying that was a prior determination. So
yeah,
he's not asking for a new determination. He's saying there was one, stick with it.
Sure, DOB at some point did accept that it was more than 200 feet from the highway, but as the Court of Appeals has held, when DOB realizes a mistake has been made, it is entitled to revoke the permits. And it is not, my colleague here makes it sound like DOB has some conspiracy against them. DOB, again, accepted their representation that it was more than 200 feet. It was only when city planning sent this letter saying we have this map that shows something different that DOB then moved to revoke
Well, your
the permit.
adversary is talking about an audit where you actually did something affirmative to otherwise establish or determine where the distance between the highway and the sign.
I think there was an audit, but it was before the letter came. And again, the Court of Appeals determination would, I mean, these are all arguments they can make to BSA. And BSA can also give them a variance.
But if estoppel applies, that is a legal argument that isn't dependent upon changing the record here, right?
Actually, collateral estoppel is a mixed question of law and fact, and this court has held that people who make collateral estoppel arguments also have to appeal to BSA.
What effect, if any, does the fact that you do have the right to revoke a permit that is erroneously issued have on any res judicata or its progeny estoppel doctrines?
My understanding is that res judicata does not apply to agency determinations at all. That's something that could perhaps apply to a court proceeding. But the prior court proceedings...
Well, it does apply administratively, but, you know...
Well, this court, the proceeding before, it was in Article 78 where the petitioners sued BSA. BSA was not really in a position to then somehow bring DOB in and have DOB make these other allegations that it could potentially have made. This can all be argued before BSA.
Thank you.
Thank you.
FX funding. You have 3 minutes. You may proceed.
Thank you. Good afternoon. May it please the court. My name is Harriet Boxer, and I represent the defendants, appellants, respondents, FoxRx et al. FX Funding has a $3 million plus judgment against the two corporations, FoxRx and ATN. It seeks to hold Doctors Deepak and Reena Nandi personally liable for this judgment under a corporate veil piercing or alter ego theory. To viably articulate a veil piercing alter ego claim, a plaintiff must show, 1, owner domination of the corporation, and 2, that such domination was used to commit a fraud or wrongdoing against the plaintiff such that the plaintiff was injured. That's matter of Morris, Court of Appeals, 1993. While there's no dispute that Dr. Deepak Nandi dominated both FoxRx and ATN, FX Funding's fatal problem here is that it utterly fails to explain or particularize how this domination was used to commit any fraud or wrongdoing.
Go ahead.
Isn't there an allegation that they used the funds to pay their personal mortgages on their houses and other personal issues which would be inappropriate, therefore committing a fraud?
Well, first of all, that's an unsubstantiated claim.
This is a motion to dismiss the complaint, if I'm correct. So the allegations have to be accepted as true for purposes of this motion.
I'm sorry, Your Honor, to assert a fraud under the test of piercing a corporate veil, you've got to substantiate what you're saying. Nonetheless, even were the court to say, well, all right, this is inappropriate, we've got this, we believe it, FX Funding does not anywhere explain how this alleged use of this money to service personal mortgages harmed it.
I'm sorry. They didn't give the money for the purposes of supporting your client's personal expenses. This was for the business. So that's obvious.
I'm sorry, Your Honor. The fact of the matter is that FoxRx was prosecuting key TAM lawsuits. The proximate cause.
And how does paying one's mortgage have anything to do with that?
What you're missing the point. The point.
No, I'm not. And perhaps you're missing the point. You have 1 minute on rebuttal. Counsel, I'll hear you.
Good afternoon, Your Honors. Sheldon Gopstein representing the plaintiff respondent, cross appellant, FX Funding. I'm glad counsel has admitted that they had total domination and control of the corporation, so we can skip over that point. As far as the wrongdoing, it's not only that they used, and we've alleged, that he admitted using some of the corporate loan proceeds, the loan proceeds for personal use, which would be improper in itself. We believe, and Mr. Shulman has alleged in his papers, that the entire key TAM whistleblower thing was really a ruse. It was a scheme to lend money from people such as my client, FX Funding. Judge Coate in the Southern District wrote blistering opinions dismissing these cases, saying they were completely frivolous. She sanctioned them. She awarded $168,000.
It's your job to do due diligence on, I mean, if you're a finance litigation company, you do due diligence on the company. You either think it's a good litigation or you don't. That's a separate issue, isn't it, than piercing the corporate veil?
It's a great question. These whistleblower cases were under seal. So all the information that my client got basically was from the Nandis or from their attorneys at the time. So they were fooled. They were fooled. If I could spend a minute on the cross appeal, in opposition to our motions for summary judgment, they brought up this elaborate, absolutely brazen lie that my client, the principal of the lender, was actually their attorney. And they went they kept going with this lie and submitted affidavits and reply affidavits. And then ultimately, on the motion to dismiss, when the summary judgment was granted and that cross motion was denied, on the motion to dismiss, he submits a whole new set of affidavits and admits my client's role. He says, yes, he was the the principal of the lender. He negotiated the loan. It's such a blatant perjury, and I believe it satisfies all three elements of frivolous conduct under the statute. Thank you, Your Honors.
Thank you. Counsel?
In order to viably assert corporate veil piercing, a party must allege that the allegation it asserts is the proximate cause of its injury. The proximate cause of FX Funding's injury is the failure of FoxRx to prevail in its Ketam lawsuits. There is no evidence before this court that FoxRx was negligent or in any way failed to honorably, vociferously, and effectively prosecute these Ketam lawsuits. If the Ketam lawsuits had won, if they had prevailed, the U.S. had intervened, and Medicare and Medicaid would then save a lot of money. FX Funding would have made out very well. It would have been very lucrative. There would be no problem whatsoever. There is no evidence before this court that any allegation FX Funding makes is the proximate cause of its injury.
Thank you.
Thank you.
City of New York versus James Horlick and versus 1600 Nelson Avenue. Counsel, you're here to argue for?
I'm here to argue for James Herrera, Your Honor. My name is Earl Wilson of the Wilson Law Firm, LLC. I was unaware that 1600 was also supposed to be here.
I wasn't sure.
Okay.
So you have 4 minutes and 2 on rebuttal, okay?
Okay, thank you, Your Honor.
Okay.
May it please the court. My name is Earl Wilson of the Wilson Law Firm, LLC, and I represent Mr. James Herrera, who was a homeowner, or is actually considered a homeowner of a property in the Bronx, in a residential area. The court is well aware of the address. He owned it since 1977. And when the time that he owned it, about 2007, there was a fire on the property, and that fire led to where we are today. We're asking this court to reverse the Supreme Court's order and vacate the default judgment that was brought against Mr. Horlick, and to set aside a deed conveying his property to the Neighborhood Restore defendants, in this case, or at least the respondents, under the TPT program. Mr. Horlick, after the 2007 fire, did not realize that there was going to be a tax placed on his property. The reason why he didn't realize that is because he sued the city of New York in 2009. He sued them in tort, and he asked that court, and that case is still ongoing, he asked that court to remove the charge of the demolition charge that had been charged on his property after the fire, 1 day after the fire, actually, which he deemed to be improper. And he also asked for the city of New York to he asked for the city of New York to he asked for, he asked for the removal of the lien, and he asked, and this is before he knew there was a tax, and he alleged that there was value to his property that should have been returned to him. Instead, in or about 2017, there was a foreclosure action brought against Mr. Horlick.
Are you maintaining that by virtue of the suit he brought in 2009, that somehow lifted his responsibility to respond
Not
to
at all.
the notices?
Not at all, Your Honor. Mr. Horlick does admit that he received some notices from the city of New York. He doesn't say that he got all of them, but he said that he received some notices indicating that there was a foreclosure. And on 10/17/2017, he sent a letter, and he sent a letter basically saying, look, I'm suing you already, and he didn't mention that he had an attorney, but he mentioned, because he started the case pro se, he said, I'm suing you already over this very same issue, and I'm basically asking you to remove this, and if you don't remove it, or if you don't get back to me, I'm going to assume that everything is okay.
I'm sorry, but that's not how city government works.
Understandable,
right?
Your Honor, but he was pro se.
So there was an obligation for him, either personally or through counsel, to follow up on this foreclosure notices he was getting.
He did, Your Honor.
And he could not rely on this tort action to somehow absolve him of that responsibility, which I think is what you're arguing.
Well, what we're saying is, Your Honor, that he gave an answer and he's pro se. He certainly at least indicated that he was appearing in the case. And that should have prevented a default process. It should have given him additional notice.
Well, the notice said if you don't pay in 4 months, that's it.
It did say that,
Right.
but Mr. Horlick is pro se. Mr. Horlick, notwithstanding the situation, was already in court, actively going through depositions, and so he had no clue. I mean, at the end of the day, his position was the city already knows, and we believe that the city had an obligation, since there was already a case concerning this issue, to at least notify the attorney in that case. And there's a case that recently has.
But wait, notified, you just said he was pro se. So
Well, he started at pro se. By the time of the foreclosure, he had an attorney.
Okay.
And he was going through depositions. The case had been stalled since 2009.
And that's even worse. So then the lawyer certainly should have known that he had to do more.
The lawyer was handling a tort matter, Your Honor, so that at the time, there was no notice even given to the lawyer. And there's a case.
Well, why should it be?
There's a case,
Was the lawyer
Dobbins
even
versus Erie County.
identified in the letter that he sent to the city?
I'm sorry, Your Honor?
Was the lawyer identified in the letter sent to the city in response to the foreclosure
No, Your Honor.
notices?
The lawyer was not identified.
Now, how is the city supposed to know that they should notify him again, or because he did it wrong, or notify some unidentified attorney?
It's the same.
It's just hard to understand where this obligation comes from.
Your Honor, it's the same office, the same corporation counsel's office, the same division. It's only a separate section of the very
Counsel,
same office.
I know that you understand that the city has hundreds of thousands of actions that they have to deal with. This isn't a mom and pop operation. Oh, Billy Joe has this problem. Did you find out about it? That's just unrealistic. But you'll have time on rebuttal, okay?
Thank you, Your Honor.
Counsel, I'll hear you. And I'm gonna, in light of the fact that we're just arguing one, I'm giving you 4 minutes, okay?
Okay.
All right.
May it please the court, Zach Shapiro for respondent, the City of New York. Just as this court has already done with respect to 4 other properties in this foreclosure action, the court should reject the challenges to the judgment here as time barred. The court in that case already recognized that the city provided proper notice in compliance with both the interim law and due process, and the record bears that out. If you look at pages 264 to 66 of the record in the Horlick case, it shows that the notice was delivered to his property address that was listed.
But if he's litigating the very issue that you're pressing on the lien in a separate proceeding, why doesn't that put you on some kind of notice that he's objecting to that lien?
Well, for several reasons. One is that this action, that tort action was from years prior. He evidently didn't prosecute it as it's still pending. because
But it's
it
not
was,
dismissed, so it's still alive.
it's not dismissed, but he couldn't possibly have intended that as an answer in this case, given that it was from years prior. He also named different city
I
parks.
didn't say that he intended it as an answer. I said, why, doesn't that put you on notice that he's that he's protesting this lien? I mean, we all want fairness here. I mean.
No, I don't think it does, because it was against different parties. It wasn't against DOF or HPD, which are the parties that administer the in-rem program. And as the Second Department recognized in the foreclosure action number 51 case, you, especially in the foreclosure context, when there are hundreds or thousands of properties at issue, you can't attribute knowledge from one agency to another agency. In that case, it was even the court declined to attribute knowledge from HPD, which co-administers the program, to DOF. So that would not be a reliable basis. But on top of that, the tort action doesn't provide any defense to foreclosure. It doesn't even cover all of the liens that were at issue in this case. It was improperly presented as a tort action, which is not a way to challenge a tax assessment. He failed to exhaust his administrative remedies, and if you're challenging a tax assessment, you have to pay the taxes. That's under well-established law, as the court recognized in Singer back in 1993. At that point, it was already well-settled law.
You always have to pay the taxes, right?
You have to pay the taxes while you're challenging them. As a final point, if you look at his complaint at page 29 of the record, he argues, he asserts that the court should cancel the lien, but he doesn't actually allege any grounds for doing so. These were emergency repair expenses that HPD took to prevent any hazardous conditions. They were completely valid, and he hasn't identified any basis to challenge them, especially given that there's already a judgment of foreclosure and he missed his time to do so. I'd be happy to answer any other questions your honors have. If not, we ask the court to affirm.
Thank you.
Your Honors, at the end of the day, we consider this to be an unconstitutional taking, and the Dorse case is telling of that. It's a U.S. Court of Appeals case that I'm sure the court is well aware of, that holds that former property owners should not be, they should be eligible to get some level of their funds back. They should, the equity of their properties back. In this particular case, the city valued Mr. Horlick's property at about 3 times the amount of the alleged lien. And also, with respect to what counsel said, Mr. Horlick was basically faced with a demolition back in 2007, and basically when he sued the city of New York, he sued them because he was continuing to pay taxes. Up until the foreclosure, Mr. Horlick paid taxes. Mr. Horlick did not understand what any additional taxes needed to be in it. And in fact, the city of New York alleges that Mr. Horlick's taxes were over and above what the lien amount was, but they were not, because Mr. Horlick maintained a payment on his taxes throughout the period of time from the 1977 until the foreclosure. With respect to any other issue, the publication, the administrative code, 11406A et sec, with respect to the Administrative Code 11401 et sec and 411.1 et sec, which deals with the transfer and fee simple absolute. Mr. Horlick maintains that there were so many different aspects of this process that does not give the city of New York the jurisdiction to take his property, without giving him any level of equity, especially given the circumstances under which he was under when the property was originally destroyed and basically demolished without his knowledge or even without his permission back in 2007.
Thank you.
Thank you, Your Honor.
People versus Harvey Weinstein.
Good afternoon to the court. I'm Barry Cammons on behalf of Harvey Weinstein. I want to begin with the juror issue, Your Honor, but before I just wanted to state very briefly that the trial court's rulings on both the Molyneux and Sandoval issues were unprecedented and not the straightforward rulings that should have been made as in any other criminal case. And these rulings cumulatively prevented Mr. Weinstein from taking the stand in his own defense and from getting a fair trial. Now, with respect to the juror issue, on January 22nd...
Could you just go back to what you started to say? You said...
I'm sorry, I can't hear.
Can you just go back? You started to say something about the nature of the rulings or the manner in which the rulings on Molyneux and Sandoval were made. What did you mean by that?
Well, Your Honor, I'm going to get to the Molyneux after I finish with the juror issue. If
If you don't mind, taking my cue as to what I'd like to hear about.
You want me to address the Molyneux first, Your Honor?
You said in your introductory statement that the Molyneux and Sandoval rulings were made in a manner that was unusual. Didn't
They were
you say that?
unusual, Your Honor, first because the Sandoval ruling is unprecedented in that it allowed 28 prior acts to come to be used against the defendant should he have testified. That prevented him from taking the stand.
You're talking about the content of the ruling then?
Yes.
Not about anything about the manner in which it was rendered. Is that correct?
Yes.
Okay. Now go ahead the way you want to. Thank you.
Okay, thank you, Your Honor. With respect to the juror issue, on January 22nd, when the juror number 11, said that there are predatory men in the book, the trial judge knew or should have known that the juror had misled the court 5 days earlier when she said they were not predatory men in the book. And this was reversible error because the judge at that point did not discharge the juror, and that was not subject.
Mr. Kamens, this whole case is about intent. Am I correct? About whether the acts were consensual or forced, what was the defendant's intent? And, I mean, the defense took a position publicly that, in the public, he didn't testify, but there were certain statements made publicly about that everything was consensual. There was the issue of the intent was hotly contested here. Doesn't that affect the court's ability to make the Molyneux and Sandoval rulings that it made?
Well, Your Honor, if you
I'm
want me to
sorry
jump...
I interrupted you on the juror again, but that's okay.
I'll get to, believe me, I'll get to the Molyneux if I can just finish the juror issue that I started. And I understand your point, Your Honor. When this judge refused to discharge this juror, it was it was a reversible error not subject to harmless error. He only asked for unequivocal assurance at that point that she could be fair, but it was too late for that. We know from the Southall case, we know from the McGregor case, that it's too late. At that point, the juror had demonstrated actual bias, and that bias could not be cured by unequivocal assurances that she could be fair. And there were many reasons why he should have discharged.
Counsel, isn't your argument that she was biased against your client undermined by the fact that she voted to acquit on, I think it was 5 of the 7 counts?
Well, she was biased for what reason, Your Honor?
I'm sorry?
I'm sorry, I didn't hear the question.
You're arguing essentially that she was biased against your client and was not fair, but isn't that...
She lied to the court.
I understand. I'm asking you a question. Isn't that argument undermined by the fact that she voted to acquit on 5 of the 7 counts?
Well, Your Honor, the fact that she acquitted the defendant on some of the counts is not dispositive of the issue that she should have been discharged immediately. It's irrelevant that she acquitted, Your Honor. She should not have, if the Molyneux issue and the Sandoval issue had been decided differently, the defendant may have been acquitted of all the charges. So I don't think it's undermined in any way. But getting back to the juror, Your Honor, she misled the court, she obfuscated, which is a nice word of saying that she lied to the court, and she had an economic interest. Her professional interests were tied to the outcome of this case. She wanted to get on this jury. She had an economic reason for wanting to get on the case. She had an economic reason for wanting to convict the defendant. And the Court of Appeals has repeatedly said that courts should leaned towards disqualifying a juror of dubious candor. No one had more dubious candor than juror number 11. It would have been the easiest thing for the court at that time to discharge the juror. Under CPL 270-15 subdivision 4, the challenge for cause was proper at the time that it was made of this juror who had already been sworn. The defense raised the ground that was not known at that time, and the defense, and as you know, no witness had testified. After the court proceedings on January 17th, the defense first learned new information about juror number 11, which they brought to the court's attention in a letter on January 20th.
Let me just stop you for a minute, because I think we have to look at this as a continuum of time. So in looking at what the judge did prior to January 17th, when the defense learned about the juror, don't we look at what the judge knew or could have gleaned from the record at that time? This is going to be a compound question. And wasn't it appropriate? And isn't a judge allowed to say, well, I believe the witness, she tells me, even though she's writing this book, that she can be fair and impartial. Isn't that okay?
On January 17th, he was allowed to believe her, but on January 22nd, when she said something which showed the court that she had lied, when she said that she could be fair, I think there was no option for the court. The court had to discharge her. It was clear that she had obfuscated and clear that she had lied to the court. The court was in a position where it could only make one decision.
Didn't the court say, as I read through the briefs, I recall reading a section where the judge he points to her reaction to his questions and how she responded in a way that gave him greater assurance that she didn't perceive the book as I'm not saying it's right. I'm just saying this is what he was saying, and part of his reasoning, that he found her to be credible when she responded with surprise at the questions that were being asked of her.
She may have expressed surprise, Your Honor, but clearly the answers she was giving turned out not to be credible. I mean, he could have believed her at that time, but how could he believe her when she gave a statement that was completely contradictory to what she had said earlier? She's a Harvard graduate. She's the author of the book. She's certainly the best person in the world to know whether the characters in that book were predatory or not. When she said originally they were not predatory, and then 5 days later said that were predatory, what other conclusion could one reach that she was lying? Despite the fact that she may have been credible, despite the fact she may have been credible at an earlier time, she now was clearly displayed a lack of candor to the court, and the court was in a position where it had to discharge the defendant. Now, Your Honor, Judge Mazzarelli—
I think you should get to the Malino issue.
I know.
Okay?
Yes.
You've taken a lot of time.
Yes, I know. Even if there were 12 qualified jurors on this panel, which there were not, the jury was overwhelmed by such prejudicial bad evidence. This was a trial of Harvey Weinstein's character. The people were making him out to be a bad person. This was a trial of his character. And the court, even if the prosecutor had successfully identified a proper basis for admission of prior acts, which it did not, the probative value was clearly outweighed by its prejudicial effect, especially when the prosecutor started out with, in this case, with having 3 unrelated sex acts as part of the indictment. It was built in Malino to begin with. They didn't need, the trial became a trial of 7 women, a dozen acts of prior misconduct.
When you talk about the acts, the uncharged acts relating to the women against whom there were charges, why wouldn't those particular incidents be really sort of part of the res gestae or part of something that would fill out the picture of what was going on here?
The people offered 2 reasons to introduce the Malino, and neither of which were justifiable. One was to show lack of consent. People versus Vargas clearly says that when the credibility, as in this case, when the credibility of a complainant is at issue, as to whether a sex act is consensual, evidence that the defendant engaged in sexual misconduct with others is not permitted and only suggests that because of it, that the defendant did something before that he did it again, which is exactly the reason we don't want this type of evidence coming into the case.
But I think my colleague was referring to the, because I separate the Molyneux issues into Molyneux rulings concerning the charged complainants and the Molyneux issues in uncharged complainants, right?
Yes.
Uncharged victims, right? So, and to me, those is two separate analysis, and I believe the question was with respect to the ones that were charged.
Right.
Why would that not have been,
Well,
that's certainly allowed.
of course, the crimes that were charged, obviously, but we're talking
talking
about
about the other
the uncharged
Okay.
crimes.
All right.
And I see my time is up. I'll say.
I'm going to give you 2 more minutes because we talked over you.
Okay, thank you. A second improper reason for trying to offer the Molyneux evidence was the district attorney said an intent to forcibly compel. Only Haley alleged force, and the defense theory was that Haley fabricated these claims of forcible compulsion. The issue was whether the forcible acts happened at all, not what the intent of Weinstein was. If the jury believed that the forcible acts happened, then Weinstein's intent would be inferred under Vargas again, which we're relying upon, from the commission of the acts, and any prior acts would be impermissible propensity evidence. Sandoval is unprecedented. Our research has not disclosed or found any case, certainly where someone has never been arrested or convicted. We've never found a case where a court would allow in 28 prior acts to be used to cross-examine a defendant.
You're not arguing that all of those rulings were improper, are you? On the Sandoval, all 28?
Well, there was no balancing at all. I think the prosecutor would say, well, they asked for 32, and we got 28. It's totally preposterous. No responsible jurist, in our opinion, would conclude that a jury could be capable of using this amount of evidence for non-propensity evidence. So the defendant is in a stranglehold. He's in a stranglehold on the direct case because of Molyneux. He's in a stranglehold on his own case because of Sandoval, and we've got a reversible error being committed in the voir dire. So he was in a legal vice in this case, and I'll save the rest for rebuttal, Your Honor.
Thank you. You may proceed.
May it please the court, Valerie Figueiredo for the people. This court should affirm defendant's conviction. Beginning with defendant's claim concerning juror number 11, there is no evidence in this record that juror number 11 lied about the subject matter of her book. In fact,
Well, she wasn't completely candid.
Respectfully, Your Honor,
At the very least, you have to acknowledge that.
Respectfully, I do not. She was entirely honest and candid. She admitted from the very beginning, from the very first January 17th inquiry, that there were teenage girls sleeping with older men. She then is asked on January 22nd whether the label predatory applied to those relationships, and she says that it could be considered predatory, but she herself did not personally consider it predatory because the girls were consenting members of those relationships. The fact that she may not have considered it predatory is irrelevant because she admitted to the facts underlying that conclusion. She told you from the very beginning that there were teenage girls sleeping with older men. In fact, her novel was not just about those sexual relationships. Her novel was a coming-of-age story set in the 1980s. It was fictional. She explained that there were other multiple storylines, such as the teenagers grappling with their parents, grappling with alcohol, grappling with drugs. This was not a book about sexual relationships or predatory older men, and she was candid about all of that. At the end of the day, the book bore no relationship to defendant. It did not concern the charged forcible conduct alleged in the case involving adult women, and it simply did not demonstrate that she had any type of bias or a state of mind that rendered her incapable of issuing a fair and impartial verdict.
Okay, why don't you deal with the Molyneux issue?
What is your rationale for introducing the testimony of the 3 uncharged victims, Young, Dunning, and Wolf?
The testimony of Young, Dunning, and Wolf, as Justice Burke found, was directly probative of defendant's state of mind. It indicated his knowledge that the women were not consenting to sexual acts simply because they had agreed to be alone with him, simply because they had come to him for professional assistance.
Why wasn't that accomplished with the 3 women who were complainants? I mean, that for me is the problem. You already have 3 women who give you 3 different types of stories of the horrors they allege they experienced with him. I think you've covered that. So to pile on with three uncharged complainants, three uncharged victims is leaning really close to that propensity line.
Well, respectfully, Your Honor, all Molyneux evidence is propensity, but the court has recognized that it's admissible when it's relevant to a material issue of fact. And here, it was relevant to defendant's intent. As Your Honor pointed out, intent was hotly contested below. The centerpiece of defendant's defense was that all these women wanted it. It was part of a quid pro quo. They were either in a romantic relationship with him, or they wanted it for they wanted the sex in exchange for professional assistance. The fact is that the testimony of Young, Dunning, and Wolf demonstrated that defendant would have understood that just because women were coming to him, were seeking his professional help, it did not mean that they were consenting to more. This is very different from Vargas, and that's the second reason.
I don't understand how that wasn't established through Mann,
because
who had a 5-year relationship with him after the assault.
Because Mann's allegations were not so unambiguous that there would have been no doubt in a juror's mind that defendant intended the forcible element of the first-degree rape. Again, when Justice Burke...
You're saying that you wanted to prove what he did with Mann by introducing the testimony of those other 3 women.
No, certainly not. Mann's allegations would have established, if believed, would have established the elements of the offense. The Molyneux evidence, however, was directly probative and rebutted defendant's defense of consent and was probative of his state of mind. It showed that defendant would have understood that women were not consenting to sexual acts simply because they sought his professional assistance. Again, unlike in Vargas, where the victim's allegations were unambiguous use of force, it was a stranger situation where there was at most 2 meetings between the defendant and the victim. It was a brutal rape where she alleged that the defendant had found her in the elevator, had blindfolded her, had dragged her to the roof of the building where he raped her. In that context, the Court of Appeals says, yes, you can infer the defendant's intent because the allegations of force are unambiguous. Here, Mann doesn't testify that she ever told defendant no. She doesn't physically resist. She shuts down and says that she basically obeyed defendant. With very little force, he's able to rape her. And for that reason, because her allegations were not as unambiguous and as stark as in Vargas, a juror might have a doubt as to what was in defendant's mind, what his state of mind was. And Young, Dunning, and Wolf's testimony demonstrated that he would have known that these women were not consenting simply because they came to him for professional assistance.
Counsel,
Where the women were of the uncharged crimes were not the victims for which were being prosecuted, though. Where was the balancing that's supposed to go on in Molyneux? This was incredibly prejudicial testimony, no?
Well, no, respectfully, Your Honor, it wasn't prejudicial for 2 reasons. One, the court gave extensive limiting instructions. 3 times the court explained to the jury.
The fact that there's instructions doesn't mean it's not prejudicial.
But here we know it wasn't.
I'm being charged with 3 rapes. And here come 3 other women who claim I did the same thing to them, but I'm not being charged with that. That's prejudicial.
Well, it's not prejudicial.
So the question is, does that prejudice, is that outweighed by some probative value that supersedes that?
Respectfully, Your Honor, it wasn't prejudicial here, and we know that, not only from the thorough limiting instructions, but from the fact that the jury acquitted defendant of the forcible rape of Mann. If they had been swayed by propensity evidence, if they had applied propensity rationale, we certainly would have gotten a conviction on the first-degree forcible rape of Mann. We didn't. Everything about the jury's careful verdict demonstrates that they followed the court's limiting instruction, they parsed through the evidence, and reached a fair and appropriate verdict.
Counsel, your opposing counsel, I'm sorry.
Go ahead.
Opposing counsel referred to the Molyneux rulings in this case as unprecedented. What cases do you rely on under New York law that actually constitute precedent for the court's rulings in this case on the Molyneux issues?
Well, parsing the Molyneux evidence, no one would quibble with the admissibility of the uncharged offenses as to Mann. Ample case law, which we...
I'm talking about the other 3 women.
Right. As to Young, Dunning, and Wolf, again, I think Vargas is a perfect illustration of precisely why we were permitted to put forth the evidence here. It's well understood that Molyneux evidence can shed light on a defendant's state of mind and intent. And in Vargas, the court makes clear you can't put it in if the intent is easily inferable from the allegations. Here, we do not have the starkly contrasting scenarios at issue at Vargas. We have one complainant, man, who doesn't even say she said no, and we have another complainant, Haley, who comes to defendant on the night of the charged offense, who was in an ongoing relationship with defendant, who defendant, in summation, argues he would have understood himself to be in a relationship with her because of the fact that she kept coming back to him, because of the fact that she sent him these emails with saying nice things. All of that made his state of mind hotly contested, as the court pointed out, and for that reason, the testimony of Young, Dunning, and Wolf would have demonstrated not only how he orchestrated these meetings in order to get these women to engage in these sexual encounters, but also his knowledge that the women were not consenting.
I'm curious on some of the Sandoval ruling. For example, I believe that it was admitted that, or allowed, that the defendant threw a table full of food onto an employee in a meeting in the late 1980s, and that you sought to use that should he testify. Am I correct?
Justice Burke reached a fair compromise. He didn't allow in any general brutish behavior.
That's not general brutish behavior?
He let in evidence of defendant's assaultive conduct, and that evidence demonstrated his willingness to further his own interests at the expense of others.
What did leaving his employee on the side of the road in a foreign country have anything to do with this sex crime case? Other than, let's put in as much as we can to show that this guy is a terrible guy.
Well, two things, Your Honor. First, all of the acts that Justice Burke ruled would be appropriate for cross-examination directly pertain to defendant's credibility and were probative of his veracity. The fact that there were many acts...
You're really arguing that this was not overkill? I mean, there were certain items in the Sandoval that I thought, okay, that's fair game. If you, after being fired, ask an employee at the company to take computers and delete stuff, that's fair game. But some of this other stuff, let's inflame the jury's heart by telling them that he beat up his brother during a meeting. I don't see how there is a balance there on that.
Well, for two things. First, below, when Justice Burke issued his decision, defense counsel never complained that that he didn't engage in any balancing. We know that the court issued a fair compromise because he ruled out any questioning regarding anything having to do remotely with sex and any... I see my time is up.
Well, he threatened to cut off someone's genitals.
I'm sorry?
He allowed in a threat to sever someone's genitals. That's got to do with sex.
But the threatening behavior, again, goes directly to demonstrating his ability to put his own self-interest at the expense of others, and that goes to the heart of honesty and integrity. The fact that there were many of these acts only indicated how defendant chose to live his life.
Yes, and counsel, you know what? There are trials every day where we have defendants who have a rap sheet a mile long. A mile long. They'll have 20 felony convictions on their rap sheet. And I've seen no judge say, go ahead, go to town on all of them, because they don't let you go into the facts. They usually just let one or two in. I mean, there is a balance.
And respectfully, Your Honor, Justice Burke engaged in that balance here. He did not allow any cross-examination regarding bullying behavior. He didn't allow any cross-examination.
But you know, when you talk about balance, and I understand what you're saying, there are certain things he didn't allow. On the other hand, suppose he would ask for 150 things. If he let in 100 things, would that still be balanced? And it's somewhat rhetorical, my question, which is balance isn't just that somebody excluded or that the judge excluded some stuff, but looking at what was let in relation to its impact on whether the jury could otherwise decide the case, not based on the fact that this is just a horrible person. That's really the balance, not what was let out.
That's correct, and perhaps if this involved a case that had 100 or 150 allegations, it would present a different scenario. But here, we do have the court having engaged in a fair compromise. He did let out a fair amount of behavior.
So 30 non-convicted, and they're not convictions, not one of them, acts. That's balanced?
Well, as you point out, the fact that they're not convictions, that they're just bad acts, if anything, makes them less prejudicial. But the fact that there were so many is only indicative of how defendant lived his life. The court was not required to unduly
You know,
sanitize
which
that.
proves the point. You're saying this is just him. He's a bad guy. There's a lot of acts because he's just bad. So, you know, to say it's indicative of how he lived his life, he doesn't get convicted because he's a bad guy. He gets convicted for these particular crimes. And so that argument, I have to admit, it's kind of rubbing me the wrong way.
I don't disagree that he doesn't get convicted for his past conduct, but in fact here, all of the evidence that he did, that Justice Burke would have permitted cross-examination on, was directly probative of his veracity. It had to do with whether he had asked other employees to lie for him, whether he used his company budget to hide personal expenses, whether he used his friend's social security number to obtain a fraudulent passport. All of that are instances where defendant's credibility are all instances that are probative of his credibility and would have been permissible lines of questioning if he had chosen to take the stand.
Thank you. Counsel?
Your Honor used the phrase piling on. I don't think there's been a case that I can recall where piling on was as evident as it was in this case. The Court of Appeals has said clearly there has to be strict scrutiny in Molyneux evidence because it's so dangerous when it comes into the jury, and strict scrutiny as to Sandoval as well. And the prosecutor said that this juror, number 11, was an extremely honest juror. If I just can quote, and within the time, does the book have anything to do with predatory older men? It's not a predatory situation at all. Does it have anything to do with the sort of individuals who young women who may be involved with older men that may be considered predatory? No. 5 days later, January 22nd, there are predatory men in the book. I don't know how much clearer it could be that this juror lacked candor and should have been discharged immediately, and it was a reversible error, not subject to harmless error analysis. Weinstein sought no special treatment here, but he expected the trial court to protect his constitutional guarantees with the same vigor as any defendant, any of the defendants you mentioned that come before the court with prior records. That's all he asked for. He didn't get it. And considering the unprecedented trial publicity, the trial court had a heightened responsibility to ensure that Mr. Weinstein received a fair trial. And that possibility was destroyed by the Molyneux ruling, the Sandoval ruling, and the challenge for cause that was not granted. Thank you very much.
Thank you.
I think it was still there. Someone turned it around. Toward the back.